the Honorable, the Chief Justice and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye. All persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the Court is now in session.
The Clerk of Court will please call the matter at hand.
Called for today's oral arguments are the consolidated cases in GR number 204819, James Imbong and Lovely Ann Imbong for themselves and in behalf of their minor children, Lucia Carlos Imbong and Bernadette Carlos Imbong, and Magnificat Child Development Center Incorporated versus Executive Secretary Paquito N. Ochoa Jr. et al. GR number 204934, Alliance for the Family Foundation of the Philippines Incorporated, represented by its President Maria Concepcion Noche et al. Versus Executive Secretary Paquito N. Ochoa Jr. et al. GR number 204957, Task Force for Family and Life Visayas Incorporated and Valeria S. Avila versus Executive Secretary Paquito N. Ochoa Jr. et al. GR number 204988, Serve Life Cagayan de Oro City Incorporated, represented by Dr. Nestor Lumicao, MD, as President and in his personal capacity et al. Versus Office of the President et al. GR number 205003, Expedito Bugarin Jr. versus Office of the President of the Republic of the Philippines et al. GR number 205043, Eduardo Olaguer and Catholic Cyberspace Apostolate of the Philippines versus DOH Secretary Enrique T. Ona et al. GR number 205138, Philippine Alliance of Ex-Seminarians Incorporated et al. Versus Executive Secretary Paquito N. Ochoa Jr. et al. GR number 205478, Reynaldo J. Chavez, MD et al. Versus Executive Secretary Paquito N. Ochoa Jr. et al. GR number 205491, Spouses Francisco S. Tatad and Mary Fanny C. Tatad et al. Versus Office of the President of the Republic of the Philippines. GR number 205720, Pro-Life Philippines Foundation Incorporated et al. Versus Office of the President et al. GR number 206355, Millennium Saint Foundation Incorporated et al. Versus Office of the President et al. GR number 207111, John Walter Huwat et al. Versus Honorable Paquito N. Ochoa Jr., Executive Secretary et al. GR number 207172, Couples for Christ Foundation et al. Versus Paquito N. Ochoa Jr., Executive Secretary et al. GR number 207563, Almarim Senti Altila et al. Versus Executive Secretary Paquito N. Ochoa. Appearing as counsels for petitioners are the following: Attorney James M. Imbong, Attorney Joe Aurea M. Imbong. Appearing as counsels for petitioner in GR number 204934 are Attorney Maria Concepcion S. Noche, Attorney Fides Angeli G. Sabio. Appearing as counsel for petitioners in GR number 204957 are Attorney Maquilito B. Mahinay. Appearing as counsels for petitioners in GR number 204988 are they're not present yet. For petitioners in GR number 205043, Attorney Nelson A. Clemente. For petitioners in GR number 205138, Attorney Ricardo Ribo and Attorney Lino Dumas. Appearing as counsels for petitioners in GR number 205478 are Senator Aquilino Q. Pimentel Jr. for Attorney Junicio Donato Garciano, Attorney Howard M. Calleja, Attorney Beatriz Aurora Vega and Attorney Jean Uy. For petitioners in GR number 205491, the following are appearing: Senator Francisco Estatad and Attorney Alan Pagia. For petitioners in GR number 205720, Attorney Rufino L. Policarpio III. For petitioners in GR number 206355, Attorney Bertini Catalunya Cosing. For petitioners in GR number 207172, Attorney Luis Francis Rodrigo and Attorney Luisito Liban. For petitioners in GR number 207563, Attorney Luis Maria Hilgana. As counsels for public respondents, we have Honorable Edsel Lagman. And for the Office of the Solicitor General, Solicitor General Francis H. Hardilesa, Assistant Solicitor General Derek Puertoliano, Associate Solicitor Christian Louis Gonzalez, Associate Solicitor Maria Cristina Navarro, Associate Solicitor Isa Catrinas San Jose Valdez, Attorney Elvira Josel Castro. For intervenors Cabral et al. And Senator Pilar Juliana Cayetano, we have Senator Pilar Juliana S. Cayetano herself, Attorney Elizabeth Aguiling Pangalangan, Attorney Herminio Hare Roque. For intervenors C4RH, IPPRP Mones Mapandi, we have Attorney Clara Rita Padilla, Attorney Marlon Manuel, and Attorney Ray Paulo Santiago. Arguing to make the opening statement will be Honorable Senator Francisco Estatad, who shall have 8 minutes. Attorney Maria Concepcion S. Noche will argue for 22 minutes. Attorney Luisito Liban for 20 minutes, and Attorney Luis Maria Gil Elgana for 5 minutes. That's all, Chief.
You may be seated, counsels. Now, may I just ask one of you to please, anyone who is authorized to speak for the petitioners regarding the manifestation of Senator Pimentel will kindly approach the podium. Attorney Calleja,
Good afternoon.
Yes, good afternoon. We received the manifestation of Senator Pimentel, and it appears to us that he has already delegated the argument on one of the issues he's going to discuss to Attorney Noche. Is that correct?
The arguments, Your Honors, have been, we have submitted in our manifestation that we will submit that in a written memorandum, Your Honors, and that the time be given to our other co-counsels so that they would be enabled to elucidate on their issues, Your Honors.
This means that there will be no oral argument anymore on local government.
Yes, Your Honors. But
Except for to the extent that it is relevant to Attorney Gana's presentation.
Yes, Your Honors.
Okay, this is understood. So we will already consider the advisory amended accordingly. There will be no discussion on the effect of the law on the local government code.
Thank you, Your Honors.
Thank you. The counsels for petitioner may please proceed. Senator Tatad, who will make the opening statement, but this is not subject to the interpellation of the justices. Is that understood? Okay.
Madam Chief Justice, and may it please this honorable court. No law is ever enacted to divide the nation. Republic Act 1035-4, otherwise known as the Responsible Parenthood and Reproductive Health Act of 2012, has not only divided the nation, but threatens to divide it further still. We come to this honorable court, therefore, to seek an end to this division. We humbly submit that RA 10354 violates the Constitution and the law of nations. The Constitution proclaims the sanctity of family life and mandates the state to defend, among other things, the right of spouses to found a family according to their religious convictions and the demands of responsible parenthood, and to equally protect the life of the mother and the life of the unborn from conception. RA 10354, on the other hand, seeks to rewrite the mandate of the Constitution by imposing population control through state-mandated contraception. Contrary to its title, RA 10354 is neither a responsible parenthood nor a health measure. It is a Planned Parenthood measure. It is a population control measure. It redefines the purpose of marriage, denies the basic right of married couples to procreate of their own free will in the privacy and sanctity of their bedrooms without state intervention. It denies equal protection of the law to those who believe they have a God-given right and duty to reject contraception, and denies to the present and future generations the right to life of the yet unconceived and the unborn. Section 12, Article 2 of the Constitution guarantees equal state protection for the life of the mother and the life of the unborn from conception. This has not affected the practice of free market contraception, which is going on in various places in the country, even as we speak here. But it unmistakably bans state-run contraception. For the state cannot function as the protector of the unborn on the one hand, and as the source of contraception on the other. It cannot be the protector and the preventer of conception at the same time. But RA 10354 irrevocably installs the state as the official provider of contraception. Not only does RA 10354 violate the Constitution, it also violates international law. For both the 1948 Convention on the Prevention and Punishment of the Crime of Genocide, which our government ratified on July 7, 1950, and the 1998 Rome Statute of the International Criminal Court, which we ratified on August 30, 2011, punish as genocide any act imposing measures intended to prevent births within a national, ethnical, racial, or religious group. State-mandated contraception or birth control is one such measure, Madam Chief Justice. True, RA 10354 allows individuals and married couples to choose between periodic continence and contraception, no matter how uneven the choice. But they cannot choose not to choose between the two methods. They must practice birth control or else suffer the consequences. That, Madam Chief Justice, is not freedom of choice at all. That is not protecting the family as the foundation of the nation and as a basic, autonomous, and inviolable social institution. That is not defending the right of spouses to found a family according to their religious convictions and the demands of responsible parenthood. That is not equally protecting the life of the mother and the life of the unborn from conception. That is simply putting the family, its most intimate private life and most precious liberties under state supervision and control. Madam Chief Justice, Your Honors, have we become a constitutional democracy only to surrender our God-given rights and liberties to state supervision and control? I don't believe so, Madam Chief Justice. Respondents say that RA 1035-4 is the result of democratic majoritarian process, and that we have come to ask this honorable court to substitute its judgment for the will of Congress. That is most unfortunate and unfair, Madam Chief Justice. We have come to this honorable court, this court of last resort, solely in search of truth and justice. The truth and justice we could not obtain from the two other branches of government. For without going back to the incidents that had clouded the passage of RA 1035-4, we believe with the Irish legal scholar Cormac Burke that, and I quote, "The binding force of the law comes not from popular consent, nor is it removed by popular dissent. It comes from justice. A just measure must be obeyed, for it carries authority. An unjust measure lacks authority and must be resisted, even if it is backed by a landslide majority," quote unquote. In 2004 in Munich, Madam Chief Justice, then Cardinal Joseph Ratzinger, now Pope Emeritus Benedict XVI, put to the world-famous German philosopher Jürgen Habermas the following question, and I quote, "Are there some things that can never be legalized, some things that always remain wrong? And are there some things that always remain legally binding? Things that precede every majority decision, things that majority decision must respect." To this honorable court, we now humbly put the same question as our own. We humbly submit, Madam Chief Justice, that excluding RA 1035-4 from our statutes, root and branch, will not take away any precious rights and liberties from those who want to practice contraception. But letting it stand for any reason whatsoever will take away not only our bedrock rights and liberties, but above all, our posterity. Yes, Madam Chief Justice, our posterity, which Black's Law Dictionary defines as all the descendants of a person in a direct line to the remotest generation, and which is inscribed as much in our DNA as in our 1935, our 1973, and our 1987 Constitution, and in the Charter of the United Nations. We cannot allow, we must not allow this to happen. Thank you very much, Madam Chief Justice. Thank you very much, Your Honors.
Thank you, Senator Tatan. May we call on now Attorney Maria Concepcion Noche.
Chief Justice, Your Honors, good afternoon. May it please the Honorable Court. Our constitutional fathers said, when we write a constitution, we write not only the fundamental law, but we also set the tone of a whole civilization. A commitment to the protection of life even in its incipient stage, is a declaration of a commitment to a higher tone of civilization. It was then, after impassioned debates and meticulous deliberations, that the primordial right to life of the unborn from conception was enshrined in Section 12, Article 2 of our fundamental law, a unique and marked distinction of the 1987 Philippine Constitution, which sets it apart from other constitutions in the world. By providing that the life of the unborn shall be protected from conception, the framers of our Constitution intended to define the beginning of human life to be at the moment of conception, and did not intend to leave it for Congress to determine. It was made clear that conception refers to fertilization, and that fertilization or conception is the meeting of the egg and the sperm, resulting in the formation of a zygote or a fertilized ovum. The Constitutional Commission recognized that the fertilized ovum is alive. It has life. It divides at a geometric rate in the continuous process of cell division and development as it travels from the fallopian tube to the uterus. This, undoubtedly, Your Honors, is a vital sign and a functional evidence of life. Also, the fertilized ovum is human. It has 23 chromosomes from the ovum combined with 23 chromosomes from the sperm to form a total of 46 chromosomes. A chromosome count of 46 is present only, and I repeat, only in human cells. It is a unique genetic composition that is neither the father's nor the mother's, but of a unique new human being. Therefore, Your Honors, there is human life at conception. The constitutional right to life of the unborn from the moment of conception is the most fundamental among all human rights, because all other rights emanate from and are posterior to it. The right to life gives birth to all other rights. Therefore, it was logical for the Constitutional Commission to recognize that the unborn has personality, though limited and presumptive, precisely to demand and claim this right to life from conception. Section 12, Article 2 is intended, 1, to eliminate every possibility that Congress will ever pass a law that legalizes abortion or makes abortion possible, and for the Supreme Court to ever pass a pro-abortion decision and to adopt the American doctrine allowing abortion as enunciated in Roe versus Wade. Second, to guarantee that the life of the unborn from conception is protected at all times, not only from death, but from every risk or threat of harm or injury of whatever form or degree, whether remote or direct, permanent or momentary. And for this purpose, every iota of doubt should be resolved in favor of the protection of that life from conception. Third, to ensure that the life of the mother and the life of the unborn from conception shall be equally protected. And fourth, to ban as unconstitutional any and all contraceptives that damage, injure, or prevent the fertilized ovum from reaching the uterus or deter the implantation of the fertilized ovum in the uterus. And these contraceptives are referred to as abortifacients. So how does the RH law square with the constitutional purpose and intent of Section 12, Article 2? Section 9 of the RH law requires a certification from the Food and Drug Administration that hormonal contraceptives, intrauterine devices, injectables, and other family planning products and supplies are made available on the condition that they are not to be used as abortifacients. Section 9 further provides that emergency contraceptive pills, postcoital pills that will be used as abortifacients shall not be purchased or acquired. Your Honors, by providing that the contraceptives are not to be used as abortifacients or that they will be used as abortifacients, hormonal contraceptives, intrauterine devices, and other family planning supplies and products have abortive capacity and can be used as abortifacients. Indeed, Your Honors, hormonal contraceptives and IUDs are, in fact, abortifacients. This approach under the RH law unquestionably puts the fertilized ovum or the human embryo at great risk because it substitutes the intention of the user for an accurate understanding of how the contraceptive works. Intending or hoping that the contraceptive once taken will not cause abortion is not a rational or defensible approach, Your Honors, because evidence abounds that once contraception is taken, it can and often will cause abortion. Similarly, a carcinogen causes cancer, regardless of its primary effect or the intention of the user. So how do contraceptives work as abortifacients? The Textbook of Obstetrics, 3rd edition, copyright 2008, and Williams Obstetrics, 23rd edition, copyright 2010. These are medical textbooks used by most, if not all, the medical schools in the Philippines, as well as Guttmacher Institute, which is the research arm of Planned Parenthood, which is the foremost provider of abortion services in the United States, Your Honors. They mention the following mechanisms of action of hormonal contraceptives that contribute to their high effectiveness. 1, inhibition of ovulation. 2nd is the thickening of the cervical mucus that retards or impairs sperm transport or penetration. And number 3, the formulations cause alterations in the endometrial lining, making the uterus physiologically hostile to receiving and sustaining a human embryo. The first 2 mechanisms, Your Honors, are truly contraceptive, which are inhibition of ovulation and and thickening of cervical mucus, because they prevent fertilization and the formation of an ovum. But we do not stop there, Your Honor, because there's a 3rd mechanism of action which is built in and a backup mechanism and which is abortive in nature. So why is it abortive in nature? Because the fertilized ovum is unable to implant in the uterus because of the action of the contraceptive that has been taken. And if there is no implantation, the fertilized ovum is destroyed and expelled from the uterus. In short, Your Honors, the fertilized ovum is killed or aborted. The abortive mechanism happens when there is breakthrough ovulation or escape ovulation. As the name suggests, Your Honors, the woman who has been taking a pill still ovulates because The formulations of the pill are such that they do not 100% of the time completely inhibit ovulation. A simple practical proof of this, Your Honors, is that there were still women who got pregnant while on the pill. And cases of this have been extensively documented. So when breakthrough ovulation or escape ovulation occurs, this may pave the way for fertilization and the formation of a fertilized ovum. The fertilized ovum then goes to the uterus, which has become hostile to implantation because the contraceptive destroys the symphony of hormones which act in concert in order to prepare the uterus for implantation. As I have said, Your Honors, because the fertilized ovum is unable to implant in the uterus, the fertilized ovum is destroyed, expelled, and killed. Your Honors, from the legal as well as moral and ethical points of view, it does not really matter how often breakthrough ovulation occurs, or whether in each instance, whether embryo death does actually occur. What matters is that the fertilized ovum is exposed to a considerable amount of risk because of the abortive action of the contraceptive, and consequently, there is a significant risk for embryo death to occur. If Your Honors please, even if there is only one life or one death that occurs, and only one human life is lost, it does not make the situation any less indefensible or any less tragic. The proviso that the FDA must certify that hormonal contraceptives and family planning supplies and products are not to be used as abortifacients is illogical and deceptive, if not ludicrous. Your Honors, once the abortifacient drugs are distributed and there is a mandate to distribute them widely, the government will no longer have any control on how these drugs will actually be used. Section 9 also mandates the inclusion of hormonal contraceptives and IUDs in the regular purchase of essential medicines and supplies of all national hospitals. Including abortifacients among the family planning methods is abhorrent enough. Including them in the essential drugs list is totally despicable, Your Honors, for being an outright affront to the fundamental right to life. Essential medicines are those that satisfy the priority healthcare needs of the population. They are selected with due regard to disease prevalence, efficacy and safety, and benefit over risk ratio. Your Honors, pregnancy is not a disease, and the only medicines ordinarily needed by pregnant women are iron and folic acid supplementation, such as ferrous sulfate and multivitamins. And pregnancy or pregnancy-related disease is not in the list of the 10 leading causes of morbidity that cause a lot of deaths all over the country. But they include pneumonia and tuberculosis. And hormonal contraceptives and IUDs are not safe. As found by the International Agency for Research in Cancer, they are classified as carcinogenic to humans belonging to the group 1 carcinogens, which include asbestos and formaldehyde. They increase the risk of breast, cervical, and liver cancer, stroke, heart attack, thrombosis, and diabetes. Hence, the mandated procurement, distribution, and use are violative of the right to health. While hormonal contraceptives and IUDs are mentioned only in Section 9, written all over the RH law is the mandate for widespread dissemination and universal access to a full range of artificial family planning methods and devices, which necessarily include IUDs and hormonal contraceptives. Hence, Your Honors, it is our humble position that the infirmity resulting from allowing abortive family planning methods is not only limited to Section 9, but extends to the entire RH law. We are not impressed with the repeated use of the term non-abortive patient, Your Honors. The term is but a ruse to discourage valid objections against the RH law and makes the violation of the Constitution all the more repugnant. The terms abortive patient or abortive patient and non-abortive patient are poles apart. One is the complete antithesis of the other. They cannot be reconciled. So when a drug is an abortive patient, it necessarily is not a non-abortive patient, and vice versa. One cannot even separate the three mechanisms of action because the third mechanism of action is built in and is designed precisely to set in when the contraceptive mechanisms fail. This must be so in order to guarantee the total effectiveness or the high effectiveness of contraceptives. Representative Lagman, the author and main proponent of the RH law, and the other respondents and interveners have conveniently redefined and re-engineered the medical terms, Your Honors. They've defined conception as synonymous with implantation and claim that there is no human life at fertilization. They also claim that life begins only at implantation. If Your Honors please, this is totally irreconcilable to the avowed constitutional intent and purpose of Section 12, Article 2. Just as our constitutional fathers consciously and deliberately took the safest and most prudent approach to ensure that human life is protected from the very moment it exists, and that no human life is killed intentionally or unintentionally. We implore this honorable tribunal to do no less and to take the most reverential and safest approach likewise, by ensuring that the life of the unborn is protected from the moment of conception and resolving every iota of doubt or uncertainty in favor of the protection and preservation of human life. We do not need to wait for evil and more evil, for death and more deaths to happen, Your Honors, before we act. Hence our petitions. The constitutional right to life of the unborn is imperiled by the tyrannical mandate of the RH law, which is going to be implemented by the entire bureaucracy, starting from the cabinet level down to the barangay health workers in the remotest barangays, backed up by the vast resources of government. Into your hands, Your Honors, we entrust the future of our unborn, who are the most underprivileged, the most vulnerable, and the most defenseless members of our society. They cannot even utter a word, or cry, or scream, or beg. So with your permission, and on their behalf, I now plead, Your Honors, let the voice of the unborn be heard in the august halls of this Supreme Tribunal. let their voice be yours. Thank you, Chief Justice. Thank you, Your Honors.
Thank you, Attorney Noche. Justice Mendoza, would you like to start?
Tony Noche, you referred earlier to the Constitution as the basis of your definition or of your statement that life begins from conception. The respondent, as you have said, has redefined it as implantation. Is this implantation of the fertilized ovum in the uterus, was this the intention of the framers regarding the definition of conception?
If Your Honors please, the records of the Constitutional Commission are very clear. There were extensive discussions on this, Your Honors, and it was very clear that the intention was that conception should refer to fertilization, and that fertilization is the meeting of the egg and the sperm, resulting in the formation of a fertilized ovum or zygote. There was no mention at all, Your Honors, about implantation.
Implantation was mentioned because apparently Congressman Lagman asked the United Nations regarding the meaning of conception, and the United Nations answered that it began with conception begins with the implantation. What do you say?
If Your Honors please, with due respect to the United Nations was not a part of the deliberations in the Constitutional Commission. And the Constitutional Commission, the records of the Constitutional Commission are very clear, Your Honor, that conception refers to fertilization, because the intention was to protect life at the earliest or at the very moment that it exists. So they very consciously and deliberately took the safest approach, lest they were afraid that human life would be lost. So there was a conscious effort to make sure that life at the very moment it exists would be protected, Your Honors.
A fertilized ovum has life already. It is a human person.
Yes, Your Honor.
It has already a DNA.
Yes, Your Honor.
How about, you mentioned about contraceptives. How about contraceptives before fertilization, which is the meeting of the sperm with the egg? What is your position on that?
On which, Your Honor, I did not quite get.
About the use of contraceptives to prevent fertilization, what is your position on that?
Well, that is allowed right now, Your Honor. Prior to fertilization, if it's because the word itself connotes that it prevents fertilization. So prior to fertilization, there's no problem with that, Your Honors.
So you have
Your
no objection against tubal ligation or vasectomy like that, and the use of condom?
Well, Your Honor, tubal ligation, vasectomy, even condoms, they cannot be classified as abortifacients. But we believe, Your Honor, that those are still objectionable because they constitute mutilation under the revised penal code.
But there is no violation of the
Section 12, Article 2.
Constitution. There's no violation.
Of Section 12, Article 2, insofar as tubal ligation, vasectomy, did you say? Yes, Your Honor.
You mentioned some contraceptives as abortifacients. How can IUD be an abortifacient?
If Your Honor, please, it's already, there have been extensive studies and findings on this that IUDs, Your Honors, they cause inflammation of the uterine of the uterus, and so they affect the uterine lining, and they also affect the capacity of the uterus for implantation, Your Honor. And so it also makes, the IUD also makes the implantation inhospitable, or the uterus inhospitable for implantation.
So you're referring to viability of the fertilized ovum.
If Your Honors, please, may I ask, if Your Honor, may I ask what you mean by viability, Your Honor?
No, I was reading the papers from the United Nations, and they said that fertilized ovum who has not reached the uterus has no probability of surviving.
If Your Honor, please, the records of the Constitutional Commission are also very clear. While viability was discussed, they did not consider viability as a factor for determining the existence of life or when protection of life should begin. As far as when asked, actually, when Commissioner Felicitas Aquino was asked about viability, she said that, you know, it is not sure whether the fertilized ovum is going to live or not. And then Commissioner Noliedo said, it's the same thing with adult human beings. You know, we are also not sure. I mean, we can also die anytime. So, and with that, Commissioner Felicitas Aquino just deferred to Professor or to Commissioner Noliedo. So viability wasn't considered at all, Your Honor, in the determination of the existence of life or when protection of life should begin by our constitutional fathers, Your Honor.
You were referring to Commissioner Noliedo.
Yes, Your Honor.
You mentioned about presumptive personality.
Yes,
What
sir.
can you say of that?
If Your Honor, please, there was also a lot of discussion about the lack of personality of the fertilized ovum to demand the right to life from conception. And it was meant, the Civil Code provision on, which is Article 40 of the Civil Code was cited. And it was said that it's only at birth that a person can is conferred a personality. First, Your Honors, we're not talking here of personality. We're talking here of the protection of life from conception, Your Honor. And then there's also that provision or the Civil Code provision which says that a conceived child is considered born for all purposes that are favorable to it. And this is, Your Honor, a provision that's favorable, definitely favorable to the unborn. So, and the protection of life will be considered meaningless, Your Honor, if the unborn is not conferred even a limited or presumptive personality. And this is just for the purpose of demanding or claiming this right to life from conception. It is not really a personality that's going to enable the unborn to enter into property relations. So the unborn was conferred a presumptive personality. And the book of Senator Tolentino also referred to a limited personality of the unborn.
Are all hormonal contraceptives abortifacients?
Yes, Your Honors. Your Honor.
about life-threatening drugs. If a pregnant woman is in danger and there is a need to administer to her life-threatening drugs, but which has the effect of aborting a child, what is your position on that?
There is a principle of double effect, Your Honor. First, we have to remember the mandate of the Constitution, which is that the life of the mother and the life of the unborn shall be, and the life of the unborn from conception shall be equally protected. So that generally, Your Honor, the life of the mother and the life of the unborn shall be protected. If that's not possible, Your Honor, then one life may be saved, okay, provided that the harm to the other life, okay, is unavoidable or unintended, Your Honor. So, in order to achieve a good, okay, the other life may be harmed, okay, but the consequence, the negative consequence, is unavoidable or unintended.
In your reply, you mentioned that IUDs are not safe. Can you expound on this?
How is that again, Your Honor?
In your reply,
Yes, Your Honor.
you mentioned that IUDs are not safe. Can you expound on this?
If Your Honors, please, IUDs also contain hormones which are abortifacients, Your Honor. And of course, we know very well that IUDs are foreign objects. And so, as I said earlier, IUDs cause inflammation of the uterus, and the inflammation sometimes extends up to the fallopian tube. So, cases of ectopic pregnancy for people or for women who use IUDs are very common, Your Honor, and they have been documented, Your Honor.
So you also mentioned that IUDs cause ectopic pregnancy.
Yes, Your Honor.
So when there is ectopic pregnancy, the fertilized ovum does not reach the uterus.
Yes, Your Honor.
So it has life.
Yes, Your Honor.
Okay.
If I may add, Your Honor,
Yes.
from the moment of fertilization, it has life.
Yes, yes. That's all, Chief.
Thank you, Justice Mendoza. Justice Carpio.
Counsel, the constitutional right to life of the unborn starts from the moment of conception, correct?
Yes, Your Honor.
Before conception, there is no constitutional life of the unborn. There is no constitutional right to life of the unborn.
Yes, your conception referring to fertilization, Your Honor.
Yeah, we'll go into that. But before conception, there is no right to life of the unborn, correct? Before conception.
Yes, Your Honor.
So before conception, you don't have any problem with the use of condom, ligation, or vasectomy, correct? Before conception.
Prior to
Conception.
Conception, yes, Your Honor.
Okay. You define conception as the union of the egg and the sperm to result in the fertilized ovum, correct?
Yes, Your Honor.
Okay. From that moment, you're saying there's already life, and that fertilized ovum deserves protection under the Constitution. Correct?
Yes, Your Honor.
On the other hand, the respondents are saying that conception happens upon the implantation of the fertilized ovum on the uterus, correct?
That's what they're saying, Your Honor.
So, if you are correct that life starts upon fertilization of the ovum, even before reaching the uterus, then the RH bill will be unconstitutional, correct?
Yes, that's our position,
But
Your Honor.
if you are wrong, and life starts upon implantation of the fertilized ovum, then the RH bill will be constitutional, correct?
If I may say something, Your Honor?
Yeah, because you're
Yes.
saying
That's-
that.
yes.
Okay. Now you are so it's now a question of when does conception occur? From the
Yes.
time of fertilization, that means the union of the egg and the sperm, or upon implantation of the fertilized ovum on the wall of the uterus.
Yes.
Okay. So you're asking the 15 members of this court, who are none of whom is a doctor, to decide when this conception happens, correct?
The records of the Constitutional Commission are, I believe, Your Honor, are clear that conception refers to fertilization, and that fertilization is the meeting of the egg and the sperm, resulting in the formation of a fertilized ovum or
Yeah.
zygote.
So you're saying that the issue of when conception occurs is a legal question. That's what you're saying.
In effect, Your Honor, that's already settled by the Constitutional Commission records or by the Constitutional Commission itself.
Yeah, but you're saying that you're asking us to decide, that this court must decide a medical issue when conception happens. Is that what you're saying?
If I may say, Your Honor, it's not a medical issue anymore, in that it's an issue that's not settled in the medical profession.
So if it is not settled in the medical profession, how do you expect us to rule? Because we will have to decide this on the basis of scientific and medical evidence.
Yes, if I may, that's what I was saying, Your Honor. It is not a medical issue because it is settled in the medical profession as shown in the medical textbooks that I cited, and even the ethical guidelines of POGS, or Philippine Obstetrical Gynecological Society, is very clear that life begins at fertilization.
Okay, you are citing, you have authorities to support your view that life starts at fertilization. Respondents have also cited authorities to say that life starts at implantation of the fertilized ovum. Correct?
Well, yes, Your Honor.
So that both sides have authorities to support their view, correct? And these are medical issues.
If, Your Honor, please, I
Do
don't...
you think the court can decide this issue here when conception happens? Or
Yeah.
would it be better for this court to leave it to Congress to decide?
With due respect, Your Honor, that's precisely the intention of the Constitutional Commission, Your Honor. They did not want to leave it to Congress to determine when the beginning of human life is. And Your Honor, the Constitutional Commission has already settled during its deliberations that conception is fertilization, and that's the meeting of the sperm and the egg, Your Honor.
The Constitutional Commission did not want a Roe versus Wade decision in this country, correct?
Yes, Your Honor.
But the Roe versus Wade does not involve conception. It does not involve conception. The issue there is not conception.
Yes, Your Honor, that's only
It's a
one.
termination of a pregnancy. That's given already. That the intention of the framers was to prevent a Roe versus Wade decision. But that is not the issue here. Correct?
If Your Honor, please, that's just one of the reasons of the Constitutional Commission for coming up with Section 12, Article 2, to prevent the Supreme Court from ever coming up with a decision similar to Roe versus Wade. But in citing that as a reason, it had to make clear when fertilization or conception actually happens and when life actually starts.
No, when the framers put that phrase, from the moment of conception, legally, constitutionally, we cannot come out with a Roe versus Wade decision anymore. That's the end of it. Because Roe versus Wade happens much beyond conception.
Right, Your Honor.
Trimester.
Yes, trimester framework. There's a trimester framework.
That has been achieved already. That is not the issue here. From the moment of conception prevents Roe versus Wade, and I don't think we can come out with a Roe versus Wade decision. So the intention of the framers have been achieved. It's different now. You are questioning, you're raising the issue when conception occurs. And medical authorities are not even sure when. They are divided. How do you expect the court to decide this?
I am very sorry, Your Honor, to disagree with Your Honor, but that's why the authorities are there, Your Honor, to show that life begins at fertilization. And that's the clear constitutional intent. Life begins at fertilization, and fertilization is a meeting of the egg
No,
and
the
the sperm.
Constitution says from the moment of conception. It does not say from fertilization.
Yes, Your Honor. But if we look at the deliberations, at the records of the Constitutional Commission, there were extensive deliberations on this, Your Honor.
What I know from my reading of the deliberations, they wanted to prevent a Roe versus Wade decision. And that's achieved. We can never have a Roe versus Wade decision here.
That's only one of the reasons, Your Honor. But a very important part of the deliberations, Your Honor, was for them to define exactly, Your Honor, when human life begins, and that is at fertilization. Conception is interpreted to mean fertilization, Your Honor.
Okay,
So-
thank you, counsel.
Justice Abad.
The Constitution, Section 12 of Article 2, states that the state shall equally protect the life of the mother and the life of the unborn from conception. So this is what you've referred to as the right to life. So this right to life belongs to the unborn,
Yes.
not to the mother or to the father.
Well, the right to life from conception.
Yes, yes.
That's
but
the right.
that,
of the-
that right belongs to the child. For example, well, I'll take myself as an example. Before I was born, I had the right to life already. Right?
Yes, 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 Your Honor.
But my right to life starts from conception. And I
Yes.
think that is the point that he was asking here. And he was telling us, I think the suggestion is that it is a medical issue, the matter of conception. But, well, do I exist when I was still in the egg, as an egg alone? Do I exist independently of my mother? No.
You are the fertilized.
Well, not yet fertilized. In the egg, is there a person already in the egg? Not yet existing
if
there,
it's
no?
if it's just the egg, Your Honor.
Not yet.
No.
Or in the sperm, not yet.
No, not yet, Your Honor.
But when the egg, when the ovum is fertilized, is that the beginning of me?
Yes, Your Honor. That's the beginning of you, Your Honor. That's the unique you exists already, Your Honor, at that point. There's a unique
Yes, because-
justice about, not a justice yet. Then.
Because the matter of my getting to the wall of the uterus is a matter for me to survive, isn't it? To get nutrition, to
Yes,
be
Your
nourished
Honor.
and to have life.
Yes, Your
In
Honor.
the same way, even when I'm delivered, I'm already born, I need to have milk. But, well, as my natural needs. So, I do not think that requires medical expertise, you know. I don't think that is a scientific problem. And may I ask you, in 1987, before this law somewhat changed the concept of conception, how did those who drafted Constitution in 1987 understand the meaning of conception?
You're referring to the members of the 1986.
Well, at the time, no, even that year, well, how did people understand conception? Is it when the egg is, the ovum is fertilized, or when the ovum travels? No, the
Yeah.
fertilized egg travels and gets to the implanted wall of the uterus.
Yes. If Your Honor, please, in my elementary, when I was in the elementary, that was what I was taught. Conception is fertilization, and that life begins at fertilization. And, it was only very recently that term was redefined, Your Honor, when all of these issues about abortifacient character of contraceptives and about abortion.
So in other words, all of us started as zygotes in a way. No?
Yes.
And then
yes, Your Honor. Yes.
and then develop into a human being.
Yes.
But it is from conception. Conception means beginning, isn't it?
Yes.
Conception means the beginning, the
Yes.
beginning of this human being,
Yes.
and that is where he
Yes.
begins.
Yes,
I think
Your
there's unanimity that that's where it begins.
Yes, Your Honor.
But it needs to be sustained by life, to life by attaching itself to the uterus.
Yes.
And later on by being fed milk when he's already born.
Right.
And
Yes,
it's not
Your
the business of my parents. It's my right, not the right of my parents. So, if they violated my right, they would not have been born. Is that correct?
Exactly. Yes, Your Honor. Yes.
If the government taught them to use abortive patient, because I think the definition of abortive patient here is, it refers to any drug
That in
or device that induces abortion or destruction of fetus inside the mother's womb. That's the fetus one. Or the prevention of the fertilized ovum to reach and be implanted in the mother's womb.
yes,
So
Your
that's
Honor.
correct. So, as Justice Carpio says, if, on this issue, if we believe that this law violates the right to life from the time of conception based on this bottom issue of when conception begins, that's how we will decide it. Is that what you mean? That's how we will decide it, our understanding of when conception
Yes,
begins.
that's a very important issue, Your Honor.
Justice Perez.
I will go to the opening statement of the good senator, and of course, you will have to adapt that you are on the same side. And he characterizes this whole bill or this whole law as a birth control measure. With that, in that context, is there any significance between implantation of the fertilized ovum or the fertilization of the ovum? What I mean is, whether it is fertilization of the ovum or the implantation of the ovum, prevention of either one is prevention of birth. Do you take that position? And follow up, if that is so, is birth control unconstitutional? What makes birth control unconstitutional?
If Your Honor, please, there was an attempt, Your Honor, during the deliberations of the Constitutional Commission to put in a provision regarding population control, but it was that did not push through because the.
So you're saying that population control is permitted under the Philippine Constitution? Is that constitutionally objectionable?
I'm sorry, Your Honor. I might have not. I did probably not hear you correctly. Were you referring to birth control, or were you referring to population control?
That's how I understood the opening statement. Population control, birth control, it's the same thing. It's what is permitted by this law, and that is what they found, what the senator found objectionable. I'm saying, in that context, both the fertilization, the prevention of fertilization of the ovum and the prevention of the implantation of the fertilized ovum, both results in birth control.
Yes, Your Honor. But then we're talking here of the effects of contraceptives, Your Honor.
I don't think we are communicating properly. If you don't take that position, then I'll let it be.
Justice Peralta.
Just a few questions. A law, when it's passed by Congress, does not go to the people for ratification, is it not? If Congress passes a bill, becomes a law, the law does not go for consultation to the citizens for approval or ratification. Is it not?
Yes, Your Honor.
But when it is a constitution,
Yes.
in order to be effective, it should be ratified by the
Has
people.
and of course, 1987 was ratified, Your Honor.
My question now is, should we also determine what the people understood by the word conception in order to arrive at a proper decision by the court?
If
Because
there are-
this one was, the Constitution was ratified by the people.
Yes,
It was
yes.
presented to the people.
Yeah, if
People voted for it. This is what we understand by conception. So, it became the Constitution.
If Your Honor, please, I don't think there's a need to further consult the people on the meaning of conception.
What I mean is, the Constitution is ratified by the people. One
Yes,
of
Your
those
Honor.
presented is this provision, Section 9 of Article 2, is it not?
Section 12.
Nine?
Section.
Section 12, brother.
That's one of the provisions of the 1987 Constitution, and by ratifying the 1987 Constitution, the Filipino people are deemed to have ratified everything in that
That's why-
1987
that's
Constitution,
why-
including Section 12,
That's
Article
why,
2,
if
Your
I
Honor.
voted for its ratification, and this is the meaning of conception, to my mind, to the mind of those who ratified it, shall we not also consider what was in the mind of those who ratified of the people of the word conception, the meaning of conception? They approve it. So if the people ratified it, then we should know what was to their mind the meaning of conception.
Well, nothing probably is going to prevent us from doing that, but there is no need to do that, Your Honor, because that's settled by the deliberations of the Constitutional Commission. And I suppose there were discussions, public debates before the ratification, and the people were informed. I'm sure that was a very controversial provision at that time. And people, I'm sure, were very interested to find out what conception in Section 12 really meant. And so I'm sure there were a lot of discussions on that, and I'm sure it was explained to them that conception refers to fertilization, because that was precisely the constitutional intent.
I am also disturbed by your statement when you were asked by Justice Carpio that if life begins at the time of implantation, then the RH bill is constitutional. Did I get you right? You said yes?
No, I did not say yes. I don't think I had a chance to
No,
answer that.
You were asked two questions. If conception simply means fertilized ovum, then this law is unconstitutional because it violates the Constitution. What if the meaning of conception is implantation, then this law is constitutional. That's what you said. Do you understand from what you said?
If Your Honor, please, the protection, the intention here of Section 12 is to protect life from the very moment it exists. And obviously, it cannot exist at implantation.
You're changing your answer.
I don't think I made...
Whether life begins at the time of fertilized ovum or implantation, as long as contraceptives are used during that period, this law is unconstitutional.
I beg to disagree, Your Honor. I did not make that statement that when it is at implantation, it is constitutional,
Okay,
Your
so
Honor.
okay, that's what I understood from the questions propounded by Justice Carpio now. You cited Section 7 in relation to Section 24 as unconstitutional. Section 7 of RA 9-10354 in relation to Section 24 as unconstitutional. This is what you argued.
Yes, Your Honor. It's part of...
But if you read Section 7, I do not find any infirmity, constitutional infirmity. Section 7 is access to family planning. Is there anything
Yes.
wrong if there is access to family
Yes.
planning?
Your Honor, family planning refers also to hormonal contraceptives as defined. It's also access to a full range of family planning methods, and that includes hormonal contraceptives, intrauterine devices, injectables, Your Honor.
But we have been, I understand that even before you get married, you are given a family planning lectures. And these are the lectures that you get before you get married. So is there something wrong if we retain this provision, Section 7, as constitutional?
That is not part of Section 7, Your Honor.
Section 7 of RA 91354.
Yes, Your Honor.
In relation to Section 24, Section 24. What I see as an infirmity probably is Section 24. Because failure to follow Section 7 becomes punitive.
Yes. If Your Honor, please, in connection with the topic or the issues I discussed during my oral presentation, Section 7 refers to a full range of modern family planning methods, and that will necessarily include hormonal contraceptives and IUDs, which I said, Your Honor, are abortifacients. So that is what is wrong with that, aside from the fact that
But it's not limited to that. It also include free care and services to indigents.
Yes, Your Honor. Yes.
So what's wrong with it?
Well, insofar as that is concerned, it's not.
That's my question is, you take away the penalties insofar as violation of Section 7 is concerned, there is no more objection. I do not see any infirmity under Section 7. In fact, it is good to all.
If Your Honor, please, Section 24, and that's going to be discussed by the next speaker, refers to, I think, conscientious objection.
No, Section 24, it's in the advisory. I'm reading the advisory.
Yes, Your Honor.
Section 7 of RA 9-10354, Section 7 is the access to family planning in relation to Section 24 thereof.
Right, yes, Your Honor.
So Section 24 penalties for non-compliance with Section 7.
Yes, Your Honor. And
So what's wrong with it?
That specifically refers to, Your Honor, to Section, not Section 23, but Section,
No,
Section
you
24.
look at your page 2.
Okay. Section 24.
Oh, yeah.
Okay, Section 24.
Section 24, penalties for non-observance of Section 7. So my question is, if you remove the penalties for non-observance of Section 7, is there an infirmity insofar as Section 7 is concerned?
Yes, Your Honor. That's precisely the point, Your Honor. Because full range of modern family planning methods, Your Honor, refers to or includes, the phrase includes hormonal contraceptives, which are abortifacients, Your Honor.
Yes, but also it includes also procedures for poor and marginalized couples having infertility issues who desire to have children. Hindi ba maganda yan? Oh.
But these are supplies necessary reasonable procedures for poor, well, depending on what these procedures are, Your Honor. But our objection to this stems from our general objection, which is that when you say full range of modern family planning methods, Your Honor, they include hormonal contraceptives, IUDs, emergency contraceptive pills, postcoital pills, and other family planning products and supplies, Your Honor, which I have said already are abortifacients and violative of the right to life of the unborn from conception.
I think your concern is that the law does not prevent abortion. I think that's your concern because
yes,
under Section 9, which is you are now objecting, you are objecting to the use of these abortifacient, intrauterine devices, injectables, and so on. There's no guarantee that if you use these methods during conception, you will not be protecting the life of the unborn child.
yes,
That
Your
is
Honor.
your objection. You are afraid that these contraceptives may be used for abortion.
They can really be used as abortifacients, Your Honor, and they are being used as abortifacients,
But
Your
that
Honor.
is conjectural.
The fact that they are being used as abortifacients
It will
and that they can be used as abortifacients, Your Honor, is not conjectural. I beg to
But that will
disagree,
still
Your Honor.
depend. That will still depend on the person. It will still depend on the person.
If Your Honor, please, as I said, the three mechanisms of action cannot be separated. So once you take the contraceptive, not all the time, the contraceptive mechanisms work. Scientific findings point to the failure of contraceptive action or actions of the contraceptive. And so when contraceptive mechanisms fail, there is a third built-in and backup mechanism which is abortive in nature. And so it's built in precisely, it is going to set in when the contraceptive mechanisms fail. And so that is what is abortive, Your Honor. That's what we're saying. So you cannot separate the mechanisms of action, Your Honor. So once you take the contraceptive, you take everything. Well, if the contraceptive actions are successful, then there's no fertilization, no ovum, no problem. But then if they fail and scientific findings point to such failure, then that is where our objection comes in. Because
Now,
that's where the abortive nature comes in.
If you remove Section 9 from RA 9 from this Republica.
Section 9, Your Honor?
Yeah, Section 9, the one that you are questioning as unconstitutional.
Yes.
Section 9 of RA 10354. Below.
Yes.
The RA is below.
Yes,
If you delete this provision, you will still have objections?
yes. If Your Honor, please, if you read the entire, my reading, if Your Honor, please, of the entire RH law, it's written all over the RH law is the mandate for procurement, this widespread dissemination and use of a full range of family planning methods. So there is a mandate for universal access and procurement and distribution of a full range of family planning methods. That's the centerpiece of this RH law, Your Honor.
I'm through.
Justice Del Castillo.
Counsel, just
Yes,
a few follow-up questions on contraceptives.
Yes, Your Honor.
You have identified contraceptives as abortifacient.
Yes, Your Honor.
There are so many contraceptives, and the respondents are taking the view that not all are abortifacient. So to resolve this issue, why don't you identify, why don't you name these contraceptives, and then let's test them.
Okay.
If they're abortifacient, then the issue is settled. So instead of making generalizations that all contraceptives are abortifacient, don't you think that the proper course of action to take is to identify
Okay.
all these? Because practically all drugs are abortifacient, even a simple aspirin. So these are just a matter of degree. So perhaps those that would cause tremendous harm, then maybe we can ban them. But unless we have that identified them, just to say that they're all abortifacient, don't you think that...
If Your Honor, please, hormonal contraceptives. What we're saying is that hormonal contraceptives, okay, which include, the pills and the injectables and intrauterine devices, Your Honor, they and the patches, Your Honor, implants, they're proven to be abortifacients, Your Honor. Vasectomy, sterilization procedures, Your Honor, they're also referred to as contraceptives, Your Honor. But they are not abortifacients because they don't, contain hormones, Your Honor.
No, I was just suggesting that so that because the respondents would also come out with their own authorities. So to resolve it once and for all, let's test them.
If Your Honor, please, we also have an objection about giving, of course, I'm sure Your Honor must be referring to delegating the authority to the Food and Drug Administration. So we have a problem with that, Your Honor, because, these hormonal contraceptives are proven to be abortifacients, Your Honor, and...
I'm not just referring to the Food and Drug Administration. My point is, let's put it to test because this is just evidentiary. It's a matter of fact. We cannot make generalizations. They're saying that these are not abortifacient. You're saying they are the abortifacient. Then let's prove it.
Yeah. If Your Honor...
That's just my suggestion.
Yes. If Your Honor, please, may I just, just bring out the very important point that we've always tried to bring out, Your Honor. Section 12, otherwise we forget this. Section 12, Article 2, mandates the protection of the unborn from conception. And that protection is not just from death, but from any risk or threat of harm or injury of any form or degree, remote or direct, momentary or permanent. And it has been proven already that anything, Your Honor, that you introduce into the body that disrupts the, workings in the uterus or the physiology in the uterus is harmful to the fertilized ovum. So,
Yes, counsel, but the protection come in only after, if I may grant you, the fertilization. So, but before that, the unborn is not protected. The unborn is protected from conception. So before that, it's not regulated act.
if Your Honor, please, before fertilization, there is no person to speak of.
Exactly.
There is no fertilized ovum to speak of. There is no unborn that needs any protection, Your Honor, at least under Section 12. So, really, the protection that we are referring to under Section 12 is protection that starts from conception. That is when we say there is already a person in that fertilized ovum that the Constitution mandates that the state protects, Your Honor.
I even concede that upon the meeting of the egg and the sperm, then there's life already. It should be protected. I concede that.
Thank you very much, Your Honor, for saying that, because there's really life there.
Thank you, counsel.
Justice, I will have to observe the order in which the hands were raised. Justice Leonen, then Justice Velasco, then Justice Bersamin, Justice Abad, Justice Reyes. I hope I get that right in the order in which Justice, after that, Justice De Castro. I'm sorry, I did not see that. Okay, so Justice Leonen and then Justice Velasco.
Good afternoon, Counsel.
Good afternoon, Justice.
And with the indulgence of my other colleagues, may I proceed to ask questions from you?
Yes, Your Honor.
To clarify some of our ambiguity
Yes,
with
Your
respect to our positions, in respect to, I think, 15 petitions and 4 comments in intervention. But first, let me just comment on the opening statement made by the Senator. We thank him for that because at least he has given us a bird's eye view of what we are to expect this afternoon, maybe until the early evening, regarding the arguments of the petitioners. It's quintessentially Senator Tatad, and I know him, and his manner of style, so to speak. May I know first if you prepared your petition yourself?
Yes, Your Honor.
Yes, and let me just go through the technical issues a little bit. This is in relation to the advisory subparagraph B, in terms of your presentation, because I felt you didn't have time to adequately cover it. But maybe just a few questions that will guide you. Your petition, is it a Rule 65 petition?
Yes, Your Honor.
So is it in the nature of certiorari or prohibition?
In our personal, in the petition of
Yes.
Alliance for the Family,
Yes.
we just captioned it as prohibition, Your Honor.
Thank you. You know, of course, that in prohibition, that there are certain acts that will only be covered by an action, a special civil action for prohibition, correct?
Yes, Your Honor.
For instance, that a quasi-judicial or judicial decision has been made, correct?
Yes, Your Honor.
Or that a ministerial act has also been made. Is that not correct?
Yes, Your Honor.
Yes. Has there been a decision in a court of law, a quasi-judicial decision, maybe by the FDA or the listing on the national formulary of drugs, or a ministerial decision on the part of the Office of the President, maybe a police out there that has caught somebody who may be a conscientious objector, etc.
Yes, I'm representing all the petitioners, Your Honor, and the petitioners have filed a petition for certiorari prohibition, Your Honor. So what, in effect, we're also saying is that there's an exercise here there's an allegation of grave abuse of discretion amounting to lack or excess of jurisdiction
Yes, that's
in
one of
coming
the-
up with the RH law.
Yes,
Your
that's
Honor.
one of the requirements. We know as lawyers that because we are not a council of the faith, nor are we medical doctors, what we can only do is act as the High Court, the Supreme Court of law in this country.
Yes, Your
so
Honor.
therefore, all we can use as our tools would be the law and the legal issues as properly framed in this case. So I beg your indulgence. So yes, that's a requirement, that there is a grave abuse of discretion. Perhaps that is properly alleged, and I concede that for now because it's not part of the advisory. The question, however, is the other parts, the other elements. You have to comply with several elements, not only one. Just because you comply with grave abuse of discretion doesn't mean that we can act on your petition immediately. Later, we will see why, perhaps through a question and answer format. But then in terms of whether you have succeeded in raising the ministerial act that you want to prohibit, may I know what the ministerial act is that you are wishing to prohibit?
If Your Honor, please, when we allege, when we question the constitutionality of a law, Your Honor, it's usually done via Rule 65, certiorari and prohibition, Your Honor. And this has been liberally construed and allowed by the Supreme Court, Your Honor, in various cases.
I am not sure about that. That this court is now wanting to act as a political tribunal that will want to shunt aside many of the precedents that we have in relation to constitutional litigation. But let me proceed. For instance, we have this presumption of constitutionality. Is that
Yes,
not
Your
correct?
Honor.
Are there cases where the presumption is not of constitutionality? In any case, that means that if there is a doubt with respect to the ambiguity of the provisions, that there may be provisions which will say abortifacient, non-abortifacient, that our standpoint, our viewpoint, should be to be faithful to our precedents and the foundation of this court in the constitutional order, that we should always accord a presumption of constitutionality.
I agree with you, Your
So
Honor.
maybe we can have that as an agreement that we have to accord this law a presumption of constitutionality. Counsel, may I know why? Do we have to accord it? Why is there such a doctrine of presumption of constitutionality?
Well, we have to presume that official acts have been done properly and correctly, and there's that presumption that official acts have been done. I mean, have been legally performed, Your Honor.
And to be fair, are there exceptions to the presumption of constitutionality? Are there any exceptions in our doctrines insofar as the jurisprudence of the Republic of the Philippines is concerned with respect to the presumption of constitutionality? Is there a situation where we can presume unconstitutionality at the get-go?
I am not aware of any presumption of unconstitutionality, Your Honor.
To be fair, I think it was raised by your third speaker, Attorney Liban, who will speak on freedom of expression. And this is when you can show us very clearly that there is such an effect. And I think it is content-based and a prior restraint at that. But we will
All
await
right.
his,
yes, I
his
recognize
presentation.
that, Your Honor.
But to our recollection, there is no reverse presumption in cases of equal protection of the law. Is that not correct? It is the petitioner that will discharge the burden of clearly showing in fact and in law that there is such a violation, a clear, undeniable violation of the Constitution. No such presumption in equal protection of the law challenges. Doctrinally,
Yes, Your Honor.
would you know of any? Because maybe our research is not that clear. Are we not correct that so far we do not have that doctrine? it is always a presumption of constitutionality. Yes. What about due process? Is there a reverse presumption? None. Also, I don't know if I'm mistaken. The due process clause reads, no person shall be deprived of life, liberty, or property without due process of law. It is one clause.
Yes.
And the due process, therefore, embeds in it the concept of the right to life, which means, therefore, that our standing doctrine is that there is a presumption of constitutionality of the act of a political department here, two political departments. And my hat's off to all your advocates here, because you have stood your ground for 13 years in the political departments and had a vote publicly done on televised nationwide. I remember that night because I had to stay up because I was riveted by the debates. Some disappointing, some inspiring, and it was drama that was happening, yes. So that was a political decision made by another department. So the right to life, therefore, there is no presumption yet of unconstitutionality. Am I not correct?
If Your Honor, please, right to life, as I said, is the most fundamental among all rights.
I agree.
It may even precede humanity. It precedes all institutions, Your Honor.
I agree.
So, if Your Honor, please, while there may be a presumption of constitutionality insofar as the right to life, this will have to be looked into very carefully, Your Honor, by no less than the guardians of the Constitution, which is
I agree.
yourself, Your Honor, and the rest.
Yes, because we are the guardians of the Constitution, we have to be very clear about our signals to the public in relation to when a political act made by democratic organs are going to be vetoed by us. And therefore, that's why I have to go through these technical issues very clearly, just to satisfy my conscience and myself that I sit here not in political judgment, but in legal judgment. So bear with me a little bit more.
Yes, Your Honor.
Yes, it's fundamental, and I guess I could concede to you that all of us, because we took an oath to the Constitution, agree that the unborn is protected from conception. But you will also agree with me that the Constitution does not mention when conception happens. Is that not correct?
The Constitution itself, Your Honor, but if something is not, if we want to really know the meaning and the intent of a constitutional provision, then of course we have to go and to go into finding out that intent, and that should be available in the records of the Constitutional Commission, which I pointed out earlier.
Decisions of this court, unanimous on the part of the NBank, Civil Liberties Union versus Executive Secretary. The interpretation of the court shall be made by this court. It shall not be made by the Constitutional Commission. We get advice from them in terms of their deliberations, but the deliberations are not all. And from one of my mentors here, Justice Peralta, I think he already gave you the clue that when people ratify the Constitution, they did not read the proceedings. They read the words. It said conception. And therefore, to a certain extent, there is some contemporariness in terms of our interpretation. Is that not correct?
There must be a presumption that the people knew what they were ratifying. And I will not be surprised, Your Honor. I was already in college probably at that time. And then there were a lot of discussions about certain provisions of the Constitution. And this must be one of those that was extensively
discussed. And the people were
discussed.
presented with the words conception, not fertilized ovum. Is that not correct?
Pardon, Your Honor?
And the people were presented with the words in Article 2, Section 14.
Section 12?
Section 12, I'm sorry. Conception, not fertilized ovum. Is that not correct?
Conception and fertilization. And when you talk of fertilization, you cannot but also think of
I'm sorry,
the fertilized ovum.
The copy of my Constitution might be wrong. It did say conception, correct? Not fertilized ovum.
Yes.
So it left it to a court of law at the proper time with the relevant issue to actually determine when conception happens. Is that not correct?
How is that again, Your Honor?
So it left it, the Constitutional Commission and the people exercising their sovereign rights to enact a constitution to a court of law to determine at some future time with a relevant legal issue to determine when conception happens. Is that not correct?
I beg to disagree, Your Honor. I think that conception is clear, has been defined by the Constitutional Commission, and there is no need for that
Nonetheless,
activity, Your Honor.
as your response to Justice Carpio, all of them my mentors, Justice Carpio now said, we are being asked by you, and you agreed, to determine the beginning of life, when life begins. And isn't that an awesome responsibility given to such secular individuals? 15 of us, not the 24 senators who were elected with millions of votes, not the 200 plus members of the House of Representatives, not the two of them acting together, not a president elected by popular vote, but you give it to us, who took an oath to read the Constitution very carefully with the provisions of Article 6 and Article 7, which creates the executive and the legislature to determine the beginning of life.
If Your Honor, please, I think it is also an inherent, a bounden duty and obligation on the part of the court, Your Honor, to respect the intent as carried out by as expressed by the Constitutional Commission, and that's
But
very
if it is
clear.
squarely raised, then so be it. Then we will have to take the vote as our conscience will guide us in terms of reading the particular law. May I go to another technical point, just so we're clear? In courts of law, how are facts established? In courts of law, how are facts established? Because I was bothered by your answers to Justice Del Castillo. In courts of law, how are facts established?
They are presented before the courts, Your Honor, and proven
By evidence.
by evidence, Your Honor.
Do we have facts? Can the Supreme Court receive evidence?
Factual evidence, no, Your Honor.
We cannot.
Yes,
and
yes, Your
therefore,
Honor.
we are now operating without facts. Is that not correct?
Insofar as the records of the Constitutional Commission, I would think that the court could take judicial notice of the records of the Constitutional
Let's go to
Commission.
that. When can a court take judicial notice? As per our rules. I'm sorry that I have to go back to our rules because I am always reminded to restrain myself with respect to my own personal and political opinions and make sure that whatever we do has to have the precedent of rule, law, or jurisprudence. So going back, how does the court take judicial notice? Or maybe to be more pointed and so that we will abbreviate this. Can we take judicial notice that a condom is an abortifacient?
If the court can take judicial notice of all the medical journals that have been written about condoms and hormonal contraceptives and other reproductive products and supplies, family planning products and supplies, Your Honor, then if the court is really interested in deciding on this very important issue, a transcendental issue of paramount importance, Your Honor, then I would like to request that the court could take judicial notice.
Some of us did, and it is robust on both sides. In other words, there are findings of this and that depending on the causality that is put forward, the method of sampling that was used, the name of the scientist that did the study. It is robust on both sides. Would you say that because of the ambivalence of the material out there, that still we can take judicial notice that a condom is abortifacient or an IUD or maybe some other hormonal contraceptive is an abortifacient?
If Your Honors have read all of these medical journals, then Your Honors must have taken from these medical journals about the risks that the hormonal contraceptives, probably not really the condom, but the other hormonal contraceptives pose to the fertilized ovum.
I'm sorry, I may have been mistaken. It may have been a misimpression. But I follow the debates, looking at the websites of almost every organization here, and follow the technical studies of both sides. And they are robust on both ends. My point being, if we are to take a factual position on a particular issue, such as when we say that all contraceptives are abortifacents, it may be, don't you think it may be irresponsible on our part?
if Your Honor, please, if you look at Section 9, there's in fact an admission that this hormonal contraceptives are indeed abortifacients
I think
and can in fact be used as abortifacients, Your Honor.
Yes,
So-
in fact, the law seems to assume that anything can be an abortifacient. Anything. And therefore, it is the use sometimes. And therefore, there is guidance from the FDA. Is that not correct? Is my reading wrong?
If Your Honor, please, just the first point. I don't think it's anything. Section 9 refers to hormonal contraceptives, intrauterine devices, and injectables.
Miscarriages of pregnancy can happen because of many causes. Is that not correct?
Yes, Your Honor. And,
the implantation- and the implantation
taking of
of the-
contraceptives is one of them, Your
And
Honor.
the implantation of the fertilized ovum cannot succeed due to many causes. Is that not correct?
It could. There are so many causes, and one of them is taking contraceptives, Your Honor.
But my confusion now is, which contraceptive are we talking about? Are we going to ban all contraceptives? Can we do that as the Supreme Court? Still being faithful to the doctrine that we are not a political organ that vetoes another political organ. We are a court of law that reads whatever is produced and looks at the facts and determines whether the facts and the law are harmonious with each other, and therefore we bring in the consequences brought by the law.
If Your Honor, please, we came here questioning the constitutionality of RH law. So, and we have not asked this honorable court to go through each of the contraceptive and say it's abortifacient. So
maybe
it's the law itself that we're questioning, Your Honor,
Which part?
because of
Maybe let's
violation of the constitutional right
Maybe
of
let's
that born.
focus on a particular law. Maybe it's not when life begins that is in question. Maybe it is Section 4, subparagraph A. And in Section 4, subparagraph A, it says, it defines an abortifacient. And again, I beg your indulgence if you follow me a little. I think there are two parts. The first one is the abortion or destruction of a fetus inside the mother's womb. I think there is no controversy there. But there is a second part, or the prevention of the fertilized ovum to reach and be implanted in the mother's womb upon determination of the FDA. Is that not correct? The
Yes,
second
I
part.
read that. It's
Focusing on the
action.
second part. If the fertilized ovum is destroyed before implantation, can it be implanted? If the fertilized ovum is destroyed before it is implanted,
No, Your Honor. If it's destroyed, it cannot be implanted anymore.
and therefore any medicine service that destroys the fertilized ovum is prohibited by this law because it is defined as an abortifacient. Would you not agree with me?
Yes, Your Honor, but then there's an IRR that changes this, Your Honor. The IRR changes this definition of the abortifacient,
Which
Your
brings me to another point. Did you plead the implementing rules and regulations?
Honor. No, Your Honor.
And therefore,
we did not. But
also a second point, if the implementing rules and regulations are contrary to a statute which governs,
the statute, of course, Your Honor.
do we declare a law as unconstitutional simply because the IRR is not correct in terms of its interpretation of the
I'm
statute?
just pointing that out, Your Honor, to show that, what is really the legislative intent for coming up, for enacting this kind of law, Your Honor.
Yes. Let me go to another point which was also covered in your advisory, and this is on the matter of a status quo ante order.
Yes, Your Honor.
Counsel, can you remind us, just to recall, what are the requirements for a status quo ante order?
There's a right violation of that right.
That's a TRO. But for a
and-
status quo ante order, you would agree with me that a status quo ante order is different from a TRO. Is that not correct?
Yes, Your Honor.
Yes. And again, you also agree with me that there is a presumption of constitutionality of a law. Is that not correct?
Yes, Your Honor.
Therefore, in order to ask for the extension of a status quo ante order, perhaps you could remind us of what are the requirements and whether we have passed scrutiny with respect to those requirements. Can you humor us with respect to that?
Well, and Your Honor, I think the existence of a right prima facie and the violation of that right, and if that right is, and if that the violation is not restrained, then it's going to cause irreparable injury, Your Honor.
Maybe just for this time, can you give me jurisprudence to support the definition of a status quo ante order?
If Your Honor, please, in the status, in the,
I mean, not a TRO. What we
Yes,
issued
Your Honor,
was a
I'm-
status quo ante order.
that's
And,
in the concurring opinion of Justice Brion, Your Honor.
which mentioned the instances where we issued the status quo ante order,
Yes,
but
Your
did not enumerate the elements. But nonetheless, may I
He
ask...
enumerated there,
Yes,
Your Honor.
may I ask that this be properly covered by both the respondents and the petitioner, because in my mind, and I may be wrong, there is a difference between a TRO and a status quo ante order. And if we are too liberal with the status quo ante order, we undermine the presumption of constitutionality. Counsel, why do we have that presumption of constitutionality again in the first place, may I ask?
Well, we have to presume that official acts have been done legally and properly, Your Honor.
Is it not because we know that the senators and the members of the House and the President of the Republic can as well read the Constitution? And that in our constitutional order, we may have the final say, we may have that finality, but we do not have a monopoly of reading the Constitution. Is that not correct?
Well, it's also my hope that our senators and congressmen know how to read the Constitution. But we have posed our hope, Your Honor, before this honorable tribunal to have the final say on what the Constitution says, Your Honor.
And therefore, if in these cases we will say that it's not yet justiciable, that there should be a case, perhaps a contraceptive going through the FDA and a finding that it is not an abortifacient, but then you would want to question it, then we can zero in on that particular fact and therefore limit the power of this court. You see, it may be possible that these 15 petitions are making us a super agency, a super department of this constitutional order, which of course, by the history of this court, we do exercise judicial restraint in that regard. My point is, if these cases are dismissed on the ground that there are still no actual facts and we would rather wait for it, is there anything wrong with that?
Yes, Your Honor. This honorable court in North Cotabato versus Government of the Republic of the Philippines, also in Pimentel versus Aguirre, have said that a mere enactment of the law is sufficient act for the court to consider it as a justiciable question.
Is that
And
the
if-
latest case, Counsel? Or
Pardon?
is the latest case Southern Hemisphere, which did again go back to the original ruling that facial challenges can only be allowed for void for vagueness as well as in relation to freedom of expression? This is by, I think, Justice Carpio Morales, if I'm not mistaken.
I think this is the latest insofar as actual case or controversy is concerned, Your Honor. Especially if, in this case, a primordial right is involved. Then, if there's an allegation of a serious violation of the Constitution, then I think, if Your Honor please, this court doesn't only have the inherent right, but the inherent duty to look into the alleged serious breach and ensure that the Constitution is upheld at all times, Your Honor.
Thank you, Counsel. I think I've taken too much time. May I just ask one more question? What is so wrong about making all this available to the public and allowing our families, our churches, our faiths to give advice as to whether this menu of options should be taken or not? Why are we patronizing in terms of our citizens? Wouldn't we be more patronizing if we tell the state not to provide a particular option, so that the choices of our citizens are limited?
If Your Honor please, this is not really a matter of making choices. This is a matter of preserving the and protecting the life of the unborn from the very moment it exists, Your Honor. So this is not about choices. This is not about choices of women or of families, Your Honor. So this is about protecting the life of the unborn from the very moment it exists.
I join you in the protection of the life of the unborn. But my question was, here is a law that simply says that government should provide the information to all that these are available. But it did not say, in fact, there is a guarantee that people are not forced to take the options that are given simply because there are options. May I know what is fundamentally, constitutionally wrong with that?
If, Your Honor, please, again, about the matter of, informing the people what the options are. I think there's a failure of informed consent here because, look, all of this, the adverse effects of contraceptives and the abortive character of contraceptives, these are not, these are not discussed openly. In fact, they're denied by the other side, Your Honor. So there's no accurate, proper information that's given out by Your Honor. It's just you provide, you disseminate widely, and there's really no choice here because effectively the government has made a choice for the people, Your Honor, with all the billions being spent
I'm
to
sorry, but
implement this.
I think the law did not say which of the contraceptives are allowed immediately. It did provide for a process going through the FDA and then a listing in the formulary. And that is, of course, very transparent. I think if you go to the website of the DOH, if I'm not mistaken, you can have a listing right there and then. And to get into that list, of course, goes through a procedure provided by the rules and regulation.
Well,
So in other words, it is not as if government is sinister enough or some part of government is sinister enough to produce it. Don't you think that there is failure of informed consent? If someone is not presented 10 options, but is limited to only 2.
but if you do not give the pros and cons for each option, then I think that's a serious failure of consent, Your Honor.
And there is freedom of expression in the sense that there is nothing in the law which prevents your organization to come out with the studies, maybe the RAND study, maybe the study by the Nobel Prize winner, stating that condoms increase promiscuity, etc., etc. There is nothing. Is there anything in the law that prevents that?
Nothing in the law, but it is also the state that has to give that information, and it's not doing that. The DOH is keeping that information from the public, Your Honor.
What particular act is it pleaded in your pleading? The particular act of the DOH that said that.
The abortive character of contraceptives that's being denied, Your Honor. I mean, it's been written about extensively. There are medical journals that's been that are there, that are available, and that's still being denied, Your Honor. Whereas if people are informed about the abortive nature, then people will decide based on their value systems and based on their convictions or religion, whether or not to avail of this particular contraceptive. But that's not being done. And that's precisely why we're here, Your Honor, because there's a continuous denial on the part of the respondents about the abortive character of contraceptives, Your Honor. So people are not informed.
Thank you.
There's no proper choice, Your Honor.
Thank you.
Thank you, Justice Leonen. Justice Velasco.
Good afternoon, Counsel. I just want to be elucidated on some matters, no? But
Yes, Your Honor.
do I get it from you that before the fertilization of the egg, before the egg is fertilized by the sperm,
Yes. Your
okay,
Honor.
any family planning method, product, or supply is allowable and cannot be assailed as being unconstitutional?
It's merely contraceptive, Your Honor. So, Section 12 does not come in, Your Honor, because there's no conception or no fertilization, Your Honor. So there's no life to speak of, Your Honor.
Correct. So you're not objecting to any
No.
family planning method, product, or
Well,
process
that's not
that prevents the fertilization of the egg. Is that correct?
Yes, Your Honor, that's not
Right.
covered by Section
So,
12.
but your concern is from the moment the egg is fertilized that you are saying this law cannot be enacted and implemented because it is unconstitutional, right?
Yes, Your Honor, if there's fertilization, yes, fertilization.
So, but Section 9 does not really say about the use of these family planning methods and products. It does not say that it should be after fertilization of the egg. It does not say so. It just merely mentions the things that can be provided to people, right?
We refer to Section 9 as, an admission by the law that certain contraceptives are really abortifacients and can really be used as abortifacients, Your Honor.
Correct.
That's why we refer to Section 9.
Correct.
Yes, and
so
there, yes.
You can interpret Section 9 to mean that these things are allowable and not considered abortifacients, right? Because the definition of an abortifacient is anything that prevents the fertilized egg from reaching and being implanted in the mother's womb, correct?
Or destroys the fetus, Your Honor.
So Section 9 is not totally unconstitutional, right?
If Your Honor, please, if the law mandates the widespread dissemination and universal access to the contraceptives, Your Honor, hormonal contraceptives, which are abortifacients, Your Honor, and this poses a great risk to the fertilized ovum or the zygote, Your Honor. Okay, so there is a presumption, that there is already the fertilized ovum or the zygote in that case, Your Honor.
But before fertilization of the egg, you cannot say any product or process or
That's clear, Your Honor.
can be considered an abortifacient, right? Because
Yes, Your
of the
Honor.
definition in the law itself. So what I'm trying to say is that why are you asking that the entire law be declared unconstitutional when certain parts can remain valid and in full force and effect even if other parts are declared unconstitutional? Because we have a separability clause in the law, correct?
Yes, Your Honor.
So some parts may be declared unconstitutional and some parts may remain valid and be given full force and effect.
Probably
Do
so,
you agree with that?
Probably so, Your Honor. Those that refer to skilled birth attendants and the improvement of medical facilities and the setting up of hospitals for obstetric care.
No, but we focus on these things that will be provided to people, like you said, contraceptives, IUDs, injectables, and the Section 9 says other safe, legal, non-abortifacient, and effective family planning products and supplies. So the legislators took into account the fact that the Department of Health should not provide abortifacients to our people, right? Isn't that the thrust of this Section 9? That they are not allowing abortifacients to be issued to our countrymen, right?
Yes, but the problem is that the contraceptives are abortifacients and the RH law still mandates the distribution, widespread distribution and universal access to these contraceptives. So it's contradictory, Your Honor. They're saying they're against abortion and against abortifacients, but but the law mandates the distribution of these hormonal contraceptives. So there's a major contradiction there, Your Honor.
But if we delete the words hormonal contraceptives, intrauterine devices, injectables, and just leave to remain the other phrases like safe, legal, non-abortifacient, and effective family planning products and supplies,
If there is
do you
any
agree that this law is constitutional?
If Your Honor, please, if there is any safe, legal, non-abortive fashion contraceptives, but there are, that's a problem, Your Honor.
The law does not say contraceptives. The law says family planning products and supplies.
And the family planning products and supplies refer or include hormonal contraceptives and IUDs and the patches and the implants, Your Honor, and the injectables, Your Honor.
No, but you must admit it's the Department of Health that will consider and determine what are those family planning products and supplies that will be provided to women, right? It is not stated here. It just simply says...
Yes, Your Honor, but then again, if the DOH and the DOH has that position that life doesn't begin at fertilization but begins at implantation, then we have an irreconcilable conflict there, Your Honor.
No, I'm not saying that. I'm following your position that conception starts at the fertilization of the egg by the sperm. And I agree. I tend to agree with your position because of the definition of the word abortifacient here, because it says to prevent the fertilized egg from reaching and being implanted in the mother's womb. And definitely the cutoff point is the fertilization of the egg. But what I'm saying is that there may be family planning methods and products that may be legally and used and constitutionally permissible that can be applied prior to the fertilization of the egg. Don't you agree that that is your position?
Insofar as Section 12, Article 2 is concerned, the non-hormonal contraceptives probably will qualify, but not like sterilization procedure and vasectomy and tubal ligation, at least insofar as Section 12, Article 2 is concerned, Your Honor.
I agree with
but
you.
hormonal contraceptives will violate Section 12,
So certain
Article
family
2.
planning products and methods can be used legally and constitutionally under this law without really entirely declaring it unconstitutional, right?
Yes, Your Honor.
Now, what do you mean by abortion? We have been talking about abortifacient. What do you mean by abortion as used in our jurisprudence?
Destruction of the fetus.
The fetus, right?
The fetus or the ovum,
That is
Your
the
Honor.
established definition of abortion, right? But it never mentioned a fertilized egg being destroyed, correct?
Fertilized ovum, Your Honor, if it's being destroyed and because of non-implantation, Your Honor, that's abortion.
So in effect, the law, with the definition of an abortifacient, probably now, in effect, modifies the definition of abortion under the revised penal code. Can you say that? Because it only talks about fetus, and definitely a fertilized ovum is not a fetus yet, right?
Well,
Because,
a fetus...
it has not reached the mother's womb.
Yes, Your Honor, Section 12... Section 12 refers to fertilization or fertilized ovum, Your Honor. It doesn't have to be a fetus if we refer to a fetus as that which has been implanted in the uterus. So, Your Honor, but Section 12 specifically refers to the protection which starts at fertilization. So, it's not a fetus then if you become very technical or medical about it, Your Honor. So, but then protection starts from there, from fertilization. While abortion may refer to, a fetus that has been implanted, but it doesn't have to refer to that insofar as Section 12 is concerned, Your Honor. Because precisely, if Your Honor, please, precisely, that's the nature of a contraceptive. It prevents the implantation of a fertilized ovum. And so it is washed out, it is expelled even before it gets implanted. That's why it's aborted, it's killed. So that's abortion in effect, Your Honor.
So in conclusion, there may be parts which may be declared, I'm not saying that will be the decision of the court, but there may be parts which may be declared unconstitutional, and there may be parts of this law that may remain valid and constitutional, correct?
Yes, there could be.
With the permission of Justice Abad, I'd like to allow all the justices to have one round first. So we have Justice Bersamin and Justice Reyes, whom I have already called, and then we proceed to Justice De Castro, unless Justice Bersamin is willing to yield to Justice De Castro. Okay, so Justice De Castro, Justice Bersamin, Justice Reyes, Justice Villarama, Justice Bernabe, and finally, may I ask my share of questions? So for the first round, before we go to the second round, Justice De Castro.
Let's go back to the term conception, which is used in the Constitution.
Conception.
We, the justices, cannot avoid trying to understand what the meaning of this term as used in the Constitution, and how our people could have understood the term when they ratified the Constitution. So I think we should go through that process of trying to understand conception.
Yes, yes.
Now, if we go by the common meaning of conception, would you agree that it connotes the beginning?
The
Beginning.
yes, yes. Conception is the beginning.
All right. So let's look at the union of the sperm and the egg.
Yes, Your Honor.
You're saying that that is when life begins.
Yes, the meeting of the egg and the sperm, Your Honor.
Now, assuming that the woman is healthy and there's nothing wrong with the reproductive organs of a woman, and the egg has already been fertilized, is there anything that will prevent this fertilized egg from developing into a human being, going through the process of development from the time of fertilization?
They say, Your Honor, life is a continuum. So when it starts when life begins and starts to exist at the moment of fertilization in the natural course, if it's allowed to develop, if the fertilized ovum is allowed to develop in the natural course without any interference, Your Honor, then of course it goes through the fallopian tube and then it embeds itself or implants itself in the uterus, where it gets nourished by the mother, Your Honor. And so it will develop into a full term and then will be born alive, Your Honor.
So it will go on its natural course unless there is an external intervention?
Yes, Your Honor. Yes, yes.
And when you implant something, do you need to implant life, a living organism, for it to develop, to continue to develop into a human being? If something that is not living is implanted,
in the first place, if it's not living, I don't think it will get implanted, Your Honor. Because, insofar as the human, embryology or physiology is concerned, Your Honor, the process of implantation is a very delicate process, Your Honor.
Point is this. Life will only develop if you implant something that is already living in the first place.
Yes, Your Honor. Yes, yes.
So, implantation cannot be the beginning of life.
It is not the beginning of life.
If you implant something that is dead, there's nothing that you can do to make it develop into a human being.
Yes, Your Honor. In the first place, I don't think it will ever implant. Because if it's non-living, Your Honor, it doesn't get implanted, Your Honor.
Already be life.
Yes,
that
there has to be
implanted.
life.
Yes, I just thought about a seedling that I plant. If the seedling is no longer living or it's already dead, I cannot do anything with it. I water it every day, put fertilizer. It will not live, even if I implant that seedling.
Exactly.
So there must be a living organism or a living thing
yes,
that
Your
is
Honor.
implanted that will grow.
Yes, Your Honor. Yes, yes,
fully.
Your Honor. fully, yes.
into a tree or into a human being.
Yes, Your Honor.
So that is, I'd like to understand conception in that sense, and I suppose that is the natural and acceptable meaning and common usage of the word
Of conception. Yes, Your Honor.
Now let's go to your other point. Is it your position that all contraceptives are abortifacient?
As I said, hormonal contraceptives, Your Honor, because the sterilization procedures are also referred to as contraceptives. But as I already explained, they may not be covered by our discussion on Section 12, Article 2.
If a contraceptive will only prevent fertilization, you will not be against that?
No, yes, we will. At least it's not covered under Section 12, Article 2.
But is it possible, medically possible, for us to identify this contraceptive that will only prevent fertilization and nothing else?
No, Your Honor. Medical findings are such that the three mechanisms of action are always present, Your Honor. You cannot separate the three mechanisms of action, which are both contraceptive and abortive, Your Honor.
Will there be a pharmaceutical company that will develop a pill that will only prevent fertilization and nothing else?
If Your Honor, please, the pharmaceutical companies will have to make sure that the contraceptives are completely effective or highly effective. And there's no drug, whether contraceptive or not, that can be guaranteed to be 100% fully effective. And so for contraceptive to achieve the optimum efficacy, then both the contraceptive effect and the abortive effect will have to be there, because the intention is there. I mean, not to be pregnant. So both the contraceptive and the abortive action will have to be there, Your Honor, in a contraceptive.
Now let's go to the life of the mother, which is also protected by the Constitution.
Your Honor.
Equally protected by the Constitution, because we've dealt with the right of the unborn. Now let's go now to the life of the mother. Is it okay to distribute indiscriminately contraceptive pills without close medical supervision?
That's very risky, and you're exposing, Your Honor, not only the life of the unborn, but the life of the mother likewise. Because, again, we cannot close our eyes to extensive scientific findings about the adverse effects of contraceptives, which have been found to be carcinogenic, Your Honor, belonging to group 1 carcinogens, together with asbestos and formaldehyde, Your Honor. So there have been findings which have been widely documented that they increase the risk of breast, liver, and cervical cancer, strokes, thrombosis, heart attack, Your Honor. We cannot, if Your Honor, please close our eyes to these findings, Your Honor, and expose the health of our women and our unborn to these adverse effects.
So the adverse effect of a contraceptive pill may be different from every woman. Not everyone may be safe, can claim to be safe.
Yes,
It will
Your
depend
Honor.
on the physical makeup of
Yes,
the
yes, Your Honor.
woman.
I suppose with any drug, Your Honor, that would be true.
So would you say that contraceptive pills should not be indiscriminately distributed without close medical supervision?
Yes, Your Honor, that is our position. This is very risky when the widespread dissemination and widespread dissemination of and universal access to contraceptives are being mandated under this law, Your Honor. That is really.
I take this seriously because I know that pills are taken daily by a woman.
Yes,
And and it may continue for many years during the time that the woman is capable of bearing children?
Yes, yes. They're supposed to be taken daily at a certain time. There's a prescribed method of taking it for it to be effective. But of course, as they say, the typical use is that, depending on lifestyle of women, then sometimes you forget, sometimes you take it on a different time. So this also accounts for the failure of these the drugs, the contraceptives, Your Honor. So, if Your Honor, please, so this will most likely happen when there's widespread dissemination without close supervision of physicians, Your Honor.
I ask this question because, when I go to the grocery to buy chicken and livestock, I always look at the notice there, organically raised, because I'm worried of eating something which has been raised through chemicals and or a natural food, and that I also think about doctors advising us not to take any substance or medicine without medical supervision.
Yes,
so I'd
Your
like
Honor.
to find out if the indiscriminate distribution of contraceptive may harm the health of our women.
Definitely, Your Honor. And that's one of that's one of the main reasons why we're objecting to the RH law, Your Honor.
We are protecting the environment from pollution.
Yes.
Would you say that chemicals being ingested by women can also cause pollution of the human body because you are altering the natural?
Of course, Your Honor. You alter the natural rhythm and harmony within the woman's body, Your Honor. And if we take to heart the ruling of the Honorable Court in Oposa versus the ENR, then that's pollution of the environment inside the woman, Your Honor, destroying the natural rhythm and harmony within the woman's body, Your Honor.
If the government will be the supplier of contraceptive pills or medications, what do you think should be the responsibility of the government for any adverse effect that may occur to any woman that will take these contraceptives, which the government will distribute and require every health service provider to distribute to our women?
Well, I would recommend that the government will answer for the medical, expenses of anyone who incurs any disease related to taking the contraceptives, Your Honor. Because knowing all these adverse effects, if the government still pushes through with the widespread dissemination of all of these contraceptives, knowing the adverse effects and knowing the abortive nature, then that's very serious, Your Honor. And the government will have to be ready to answer for the consequences.
So if one develops cancer or dies out from a stroke brought about by the use of contraceptive pills, should the government be answerable for that?
I would think so. Yes, Your Honor. Definitely.
Justice Bersamin, Justice Reyes, Justice Villarama, and then Justice Reyes, if Justice Reyes will yield, and then finally, I will ask questions. Justice Bersamin.
Thank you, Chief. Counsel,
Yes, Your Honor.
you have no basic objection to the use of contraceptive drugs or supplies?
Basing on Section 12, Article 2, again, was a question, Your Honor. I'm sorry.
You have no basic objection to the use of contraceptive drugs and supplies? Because we are not talking yet about life as far as their use is concerned.
If Your Honor, please, if there's no fertilized ovum, if Your Honor, please, again, the mechanisms of action of a contraceptive are inseparable. You cannot separate them. So once you take a contraceptive, even if you say this is just for contraception, you cannot prevent, you cannot manipulate what's going on inside your body and say, after when a fertilized ovum is formed, then I will have to protect it. No, because a contraceptive has both contraceptive mechanisms of action, and if these contraceptive mechanisms of action fail, then the abortive mechanism automatically sets in. So right now, there's no hormonal contraceptive, according to medical journals, that has no abortive character, Your Honor.
What about spermicides? What are they?
Spermicides.
Spermicides.
Well, I would think that they're also
They are not
contraceptive.
hormonal contraceptives in your thinking.
I am not.
I'm just concentrating on sections 7 and 9
Yes, Your
of the
Honor.
law. I wanted to be assured that we understood each other. All the while, we have been talking more about abortifacients. And you
Yes,
have made it very clear to me, at least, that an abortifacient, as defined by the law, refers only to a zygote. To prevent that zygote
Yes,
from being
yes.
implanted in the mother's uterus.
Or destroying that zygote.
Yes.
Yes.
Before the union of sperm and egg, do you factor that at all in your arguments? This afternoon?
Before the union of the egg and the sperm, there is no life yet.
There is no life.
So there's no life to be protected,
protected.
under Section 12.
So
yes.
you have no objection to condoms,
Not under Section 12.
even
Article
if there is already information that condoms sometimes have porosity.
Well, yes, Your Honor, there are scientific findings to that effect, Your Honor, but I am discussing here Section 12, Article 2, Your Honor. Yes,
All right.
and it's not, I have to admit, it's not an abortifacient, Your Honor.
Okay. Now, we talk about contraception, conception, that is your name, by the way,
Yes, Your Honor.
as the union of sperm and egg.
Yes,
Have we
Your Honor.
established at all, in science at least, how fast does the sperm travel to that union after the coitus?
I understand, Your Honor, that the sperm only lives for 1 day.
No, I was asking about the speed.
Yes, yes. I'm not so sure, Your Honor,
You're
about
not
the
so
speed.
sure. All right. Since it is not possible for us at all to establish the physical time when the union between sperm and egg happens or occurs, okay? Have you surmised at all how long? Surmised. How long, probably after the coitus, did that union happen? Is it in seconds, in moments, or a day or two?
I think a day or two, Your Honor.
A day or two, and by then the sperm shall have died along the way. Di ba? You said that the sperm can survive only for 24 hours?
1 day.
Is that?
Is that? I'm not. I think that's a
Well, anyway,
lifetime of the sperm.
I will not go into that further. Let me focus on Section 9.
Yes, Your Honor.
I don't see anything objectionable to Section 9 because I think it is only about listing or delisting from the national formulary or the formulary system that this section adopts. But your opinion is otherwise. Why so?
If Your Honor, please, the second paragraph says, these products and supplies shall also be included in the regular purchase of essential medicines and supplies of all national hospitals.
Yes, but you omit the important parts of this section, that they are under supervision, that there is a warning against the abuse of these materials.
It says, provided further, the foregoing officers shall not purchase or acquire by any means emergency contraceptive pills, postcoital pills, or abortifacient that will be used for such purpose, and their other forms are equivalent. But the purpose is, Your Honor, our position is that these hormonal contraceptives are abortifacients. So, in the declaration of policy, the RH law says that it doesn't intend to legalize abortion or make abortion, but with this, it makes abortion possible because they're saying here that in fact they're admitting here, the law admits in fact that hormonal contraceptives are abortifacients are abortifacients and can be used as abortifacients. And despite that, Your Honor, there is still this mandate that they be included in the regular purchase of essential medicines, Your Honor.
But the first paragraph of Section 9 contains that particular part, which says they must have a certification from the FDA that said product and supply is made available on the condition that it is not to be used as an abortifacient. You do not trust government?
If Your Honor, please, our position is, how can government still monitor how the contraceptives will actually be used after they have already been distributed? So the FDA will just certify, but then after certifying and then the contraceptives are distributed, how is the government going to determine that these contraceptives are not in fact going to be used as abortifacients?
And then in the second paragraph, that is the one that you cited, the proviso, that the foregoing officers shall not purchase or acquire by any means emergency contraceptive pills, postcoital pills, abortifacients that will be used for such purpose, and their other forms or equivalent. You do not also trust the government to do this?
Well, again, this is an admission that these emergency contraceptive pills and postcoital pills are abortifacients. Why say provided that they're not going to be used as abortifacients? In effect, this law says that there is an abortifacient character of emergency contraceptive pills and postcoital pills. So if we take into consideration an understanding of how the contraceptive works, which is that the three mechanisms of action are always together and cannot be separated, then this doesn't really make sense, Your Honor. Because if you recognize that this can be used as abortifacients, then why make it part of the regular purchase of essential medicines? And once these are distributed, there is no way that government can determine or will have any control over how these contraceptives are going to be used.
Okay.
So,
I will leave that. But I will go to Section 7, which is the other section or provision that is assigned to you for argument. I have been hearing you from time to time mention about this phrase, full range of modern family planning methods.
yes,
And I
yes,
noticed from the tone of your argument that you do not like this phrase. Why so?
it's a full range. So anything, any modern family planning method, and this necessarily will include hormonal contraceptives and intrauterine devices. When I say hormonal contraceptives, this include not just the pills, but the injectables, the implants, the patches.
But if you will read Section 12 of Article 2 of the Constitution, which you have been citing every now and then,
Yes.
you do realize that that section says that the right of the unborn and the right of the mother are equal.
Yes, Your Honor.
Will you not, in that light,
Oh,
tolerate this provision, Section 7, even if it contains the phrase full range of modern family planning methods?
What's the question? I'm sorry, Your Honor.
Now, given that in that provision, Section 12 of Article 2, there is an equality between the right of the unborn and the right of the mother,
It says...
will you not tolerate Section 7, even if it contains this phrase that you have been raising hell about this afternoon?
In effect, you're pitting the mother against the unborn.
No, I am not saying that. They have equality of rights. But supposing it is the mother that demands this full range of family, full range of modern family planning methods, and it collides with the right of the unborn.
Yes, Your Honor. Because the mother doesn't have the right to, to not necessarily to kill, but to to expose the fertilized ovum to unnecessary risk, Your Honor, posed by the abortive character of the contraceptives. So that the mother doesn't have the right, that right, Your Honor, and the mother doesn't have that choice. While, again, it's a right to life that's at stake here, which is more supreme, more fundamental than any private right of the mother to exercise her choice to, enjoy in sexual pleasure without any responsibility.
Well, anyway, I am done today. Thank you very much for your answers.
Thank you, Your Honor.
Justice Villarama.
Thank you, Chief. Lady Counsel, so
Yes,
just
Your
one
Honor.
or two questions. We've been standing there for more than 2 hours already. Now, still on this full range of modern family planning methods, if there may be other types of contraceptives that are proven safe and have no psychological effect on the mothers, let's say declared by the Department of Health or the DFA to be safe, proven, would you still maintain the constitutional objection on the ground that it violates the right to health?
If Your Honor, please, okay. Again, I think it's very, very important that there is a recognition first of when life begins. Because if our government agencies maintain that life begins at implantation, as I think it is the position adopted right now, then we have that's an irreconcilable difference, Your Honor, because that will really pose, unnecessary risk on the life and safety of the fertilized ovum. So if there's and that's also our position insofar as delegating the right to DFA to determine which are abortifacient or not. Because if the standard is that life begins at implantation, then we really have a serious problem there. So, but if there's an agreement that life indeed begins at fertilization, which is the correct thing, Your Honor, because life really begins at fertilization. If there's an agreement insofar as that is concerned, and if science has improved and is able to develop a contraceptive that's truly safe, then definitely we will not have any objection to that, at least insofar as Section 12, Article 2 is concerned.
Do I get you right that any contraceptive, you're against it?
Right now, Your Honor, because there are no contraceptives, hormonal contraceptives, when I say contraceptives, hormonal contraceptives that are proven to be safe and non-abortifacient.
Okay. Let's go to this natural family planning. The law mandates also the implementation of this natural family planning, correct?
Yes, Your Honor.
Would you have no objection to a legislation that exclusively promotes and requires the use of natural family planning methods by all Filipino couples? Will it be less morally objectionable if only the NFP is allowed by law? Is there any existing church program that educates and supports natural family planning methods? If so, have they determined its success rate in terms of naturally preventing pregnancy?
If Your Honor, please, insofar as Section 12, Article 2 is concerned, which is the basis of our petition, then if we talk of natural family planning method, we're not talking of any hormones or hormonal contraceptives, of course. And probably if government will spend the 3 billion pesos into, explaining how natural family planning method or the different methods of natural family planning could be done, then probably we'll achieve whatever this RH law seeks to achieve, Your Honor.
Don't you think the anticipation of pregnancy prevention in natural family planning method based on the woman's fertile period also amounts to an anti-life behavior, considering that it has the same result? Prevention of fertilization.
No, I don't think it may. It doesn't. The process is very different, Your Honor, because again, there is no risk that there is going to be a fertilized ovum who's going to be exposed to risk. There's not going to be any fertilization in the event of in case of a use of natural family planning method, Your Honor.
That's all. Thank you.
Justice Reyes.
Good afternoon, Madam Counsel.
Good afternoon, Your Honor.
You mentioned that under Republic Act 10354, it violates even the international law affecting...
I'm sorry, but I cannot hear, Your Honor.
You mentioned during your disquisition that... can't hear. You mentioned that during your disquisitions that under Republic Act 10354, it violates even the international law affecting the crime of genocide. Am I right?
Yes, that's the subject of, Senator Tatad mentioned that, Your Honor.
We must, Madam Counsel, we must emphasize that the law protects the right to life of unborn child from conception. It does not sanction the killing or abortion of the unborn child. It only prevents the meeting of the sperm and the egg. Am I right, Madam Counsel?
That's the declared policy, Your Honor. But if you look at the different provisions of the RH law very carefully, the declared policy is not being carried out, Your Honor, because that's our position.
But is it not in genocide, the lives of whether the unborn or the born human beings, they are completely annihilated? Or
Yes, precisely, Your Honor. So even those who...
I don't see any
even those who are
similarity.
Yes, those who are not conceived yet or not yet the unborn.
From my point of view, the constitutional intent is to prohibit the passage of an abortion statute.
Yes, that's the constitutional intent, Your Honor.
And not to prohibit contraception?
To prohibit abortion or making abortion possible, because the Constitutional Commission, took a the safest approach, a very prudent approach, in order to protect that unborn, from the moment of conception.
Do you agree with me, Madam Counsel, that the purpose of the law is it is a contraception statute rather than abortion statute? Can you agree with that proposition, Madam Counsel?
So in short, that it prohibits contraception. What is the point, Your Honor? I'm sorry, I cannot understand.
Under that specific law, it is a contraception statute rather than abortion statute.
The RH law, you mean, Your Honor?
Yeah, that particular law, RA.
It provides for widespread contraception, Your Honor, which may lead into abortion, Your Honor. That's our position. Because of the mandated widespread dissemination of contraceptives, Your Honor, then that may lead to abortion. That's our position, Your Honor.
Well, do you agree with me, Madam Counsel, that one of the plausible solutions to our country's population growth problem is family planning, whether it entails natural or artificial methods of planning? Do you agree?
If Your Honor, please, the question is premised that the big population is a problem. The RH law also says that human resource is an asset. So, by saying that, then it should not recognize the population, the big population, as a problem, because it should be an asset of the country. And the Philippine Constitution has done away, while it was in the 1973 Constitution about controlling the population, the 1987 Constitution did away with the provision on population control, Your Honor.
But let us be practical, Madam Counsel, and we have to succumb to reality of life. Of course, you will agree with me, Madam Counsel, that the majority of the Filipinos belongs to underprivileged and poor families. Would you agree with me on that?
Yes, many of us are poor. Yes, Your Honor. That's a fact.
That based on statistical census, the poorer the families are, they have more children than most of us who are more privileged, educated, and affluent. Agree, Madam Counsel?
Well, there are statistics, there's some findings to that effect. Yes, Your Honor.
Statistics-wise, the children of most of the underprivileged and poor have less access to basic necessities in life. That is shelter, education, food, medicine, and they are living under the state of helplessness and hopelessness. And the government, and so much of the government funds subsidize the poor and the underprivileged. Would you agree with me?
Yes. Well, if Your Honor, please, I think the problem, while poverty is a problem, I think population control is not the solution, nor is this contraception a solution. The solution to that, Your Honor, is proper governance and setting up the right priorities, Your Honor. So we're barking at the wrong tree, Your Honor. I mean, the government is barking at the wrong tree.
One of the purposes of the government, dissemination, information system, in order for the people who are most specifically those who are less privileged, and the poor to have knowledge that they should contain their children. Is it not? That's one of the purposes of that specific law, Madam Counsel.
Yes, Your Honor, but then you do not accomplish that by spending billions of pesos on harmful contraceptives, Your Honor, because you're not solving a problem, you're adding more problems, Your Honor, in that way. And you cannot really foster the common good in that sense, Your Honor.
Do you agree with me, Madam Counsel, that chances are the same people, meaning to say the less privileged and the poor, would multiply and multiply, and the cycle will repeat by itself?
Yes, Your Honor. If the solution is contraception, then you're not really addressing the root problem of poverty, Your Honor. Then poverty continues, and because more people are going to get sick, many people are going to get hopeless because they remain poor. Because when you introduce contraceptives, you don't put food on the table. You take contraceptives and that's it. You do not address your poverty.
But the government is trying its best to solve the influx of populations, because at this point, we all know that majority of the Filipinos belongs to underprivileged and poor families. And chances are this same group of families will multiply and multiply. And there will come a time that the government would no longer support the needs of those people.
But there's a fundamental problem there, Your Honor, because by doing that through contraception, then you're not really looking after the unborn. And then, as Senator Tatad said, the posterity. I mean, you do not secure the right to life of the unborn and posterity, because eventually wipe out. You cannot speak of future generations anymore if you just concentrate on this contraception. So you're not addressing the problem, but you're compounding the problem, I would say, Your Honor.
Of course, you do believe that natural method should be natural method.
It could be considered. It could be considered, Your Honor.
Belief. And at the same time, we have to respect the beliefs of other people that artificial contraceptions would also be applied, Madam Counsel. Artificial.
Yes, Your Honor, provided it doesn't go against other provisions of the Constitution, like the right to health, right to life of the unborn, and right to health of the people. Yes, people can exercise their freedom of choice, provided that's not going to affect the more fundamental rights of other people, like the right to life, which is the most fundamental among all human rights. So it enjoys, priority in a system of hierarchy, Your Honor. Nobody is free to exercise a choice without considering the rights of others. I don't think that's what the Constitution says too, Your Honor.
Thank you, Madam Counsel.
Okay. Attorney Concepcion.
Yes, Chief Justice.
No, I was just trying to lighten the moment because you seem already tired. But I would like you to think of the complicated nature of the questions that are before us. If I would allow you to imagine a particular situation that I and the other justices of this court could very well be faced with. I have a very good clerk, for example, and this clerk helps prepare the agenda that is going to be deliberated upon by the Supreme Court. Now, this clerk is therefore involved in a very confidential function. That clerk can actually sell information about our agenda items, and people know that there are buyers of information about confidential matters in this court. Can you imagine that?
Yes,
Okay.
Your Honor.
In a buyer's market, that clerk can pass on information that can be sold for 10,000, 20,000, 50,000, depending on what kind of information we are talking about. That is why we're very, very strict with the confidentiality of our proceedings. You understand that?
Yes, Your Honor.
Because it is important for the administration of justice for our proceedings to be kept confidential.
Yes,
Okay.
Your Honor.
But that clerk is only salary grade 6. That means that the salary of that clerk of the Supreme Court, whom I value very much, and whom I entrust with the safety of confidential information of national importance that could actually be sold to corrupt people for a lot of money, salary grade 6 will only yield that clerk 10,000 pesos a month. Okay? Can you imagine that?
Yes, Your Honor.
Now, I have noticed that this clerk has been absent lately. And so I do not wish to lose that clerk. Because of the honesty of that person, I call in that clerk and ask her what has been the problem. And she shares with me the fact that she has too many children to attend to. Would you have an idea how much the rental of a very small 6-square unit in an informal dwellers community would command right now, assuming that that clerk lives within the Metro Manila area? Would you have an idea?
5,000?
Yes, correct. So from a 10,000 peso basic salary, that clerk, after some deductions, of course very minimal because that is a very small annual income, would only bring home a net of 4,000 plus. But if you are going to deduct operating expenses, that leaves a net of 2,000 plus to that clerk.
Yes, yes.
And I value that clerk, but I cannot increase, we cannot, none of us, not even the 15 of us, can increase her salary because we have to follow the salary standardization law, much as we want to. And we are in danger of losing the services of a very good clerk because her take-home pay is so small. You understand?
Yes, Your Honor.
Her problem is she has so many children. And I ask her, why do you have so many children? And she says, ma'am, may asawa po ako. Am I committing an impeachable offense if I tell her, bakit hindi ka mag-family planning?
Yes, Your Honor.
Yes, I am committing an impeachable
sorry.
offense.
Yes.
If I had asked the clerk kung bakit hindi siya mag-family planning?
No, I don't think so. I mean, I don't think you're committing an impeachable offense because are you referring to a violation of the Constitution?
Yes, because you're saying that the state has the duty to protect the life of the unborn, which is from the moment of fertilization.
Yes,
now,
Your Honor.
you're saying that all contraceptive pills has a third action, which is to prevent implantation. So if I'm telling her, go and see a medical doctor in a government clinic and ask for a contraceptive pill, am I committing a violation of the Constitution by asking a government employee to cause the non-implantation of a fertilized ovum?
If Your Honor, please, I think the employee will have to be informed of the consequences of...
So your legal problem is only with the information. If therefore it is only the right to information, and the medical doctor in that government clinic says, if you take this contraception pill, it has the third action, and she says yes, am I and she violating the Constitution?
Yes, Your Honor.
We are both violating the Constitution simply because I asked her to go to a doctor to ask her about the contraceptive pill.
The person who actually uses contraceptive, Your Honor, knowing that it could cause the abortion of her
What
fertilized
if
ovum.
she says she is not getting young? An additional pregnancy is already deleterious to her health. Is she committing a violation of the Constitution?
It means that, she still continues to do what she wants to do without concern for...
No, don't worry about the concern.
That's why, Your Honor.
The question is simple. She feels, because of her many children and her work here in the Supreme Court, if she continues to have children, in the long run, it will be very dangerous to her health. Is she violating the Constitution?
I would think so, yes.
So
yes, Your Honor.
there is a constitutional duty of a woman to expose herself to health risks as long as the fertilized ovum is not prevented from being implanted.
Okay, right now, Your Honor, the contraceptives are not illegal.
No, that's simple. Is there therefore? Because if you are saying there is a violation of the Constitution, then there must be a duty. Is there a duty on the part of the woman who believes that her health is already being exposed to risks to continue allowing such risks to attend her?
Yes.
Because she will not do anything to prevent the implantation of a fertilized ovum in the womb.
Okay, Section 12 says the state shall equally protect the life of the mother and the life of the unborn.
How
So
is
it's the state, Your Honor.
That's the Justice Bersamin has already asked you. The Constitution says they are of equal importance. But everything that you have basically said is focused on the primacy of the right of a fertilized ovum.
Yes, Your
to
Honor.
be implanted.
Yes.
You are saying it is primacy. So the interpretation is that there is primacy, but the Constitution uses the word equality. What are we going to use?
Well, if Your Honor, please, it depends. No, if you're talking of the life of the woman because she is she's getting old.
Day, she feels that she can't even eat properly. She's even in danger of losing her job. It is obvious to her that her physical condition, her material condition is deteriorating, and she receives this advice. Does she now have the constitutional duty to ensure that a fertilized ovum is implanted in her womb?
I think, yes, Your Honor, she has to make sure that the baby inside her is also protected because the baby has as much right to her life inside her, and she has that responsibility.
Let's read Section 12 again. You forget that there are two other sentences in Section 12. Do you have Section 12 with you?
Yes.
Okay, read it from the beginning.
Okay, only have the second sentence.
No, you cannot read a constitution in a chopped manner.
Yes, Your
You
Honor.
have the duty to make sure that the context is complete.
Yes, I will do
Okay,
that.
where is it? Please read it for us.
Okay, the state recognizes the sanctity of family life and shall protect and strengthen the family as a basic autonomous social institution. It shall equally protect the life of the mother and the life of the unborn from conception. The natural and primary right and duty of parents in the rearing of the youth for civic efficiency and the development of moral character shall receive the support of the government.
In the third sentence, it is where the word primary is used. The natural and primary right and duty of parents in the rearing of the youth for civic efficiency and the development of moral character shall receive the support of the government. In
Yes,
other
Your
words, we are talking about several things here. The marriage is the basic social unit as defined in the first section. The second sentence talks about the equality of the right of the mother and the right of the unborn child. The third sentence talks about the ultimate duty of the parents with the support of the state to rear the youth for moral and civic efficiency.
Yes,
Which
Your Honor.
means that there is a goal. And the goal is to enable that kind of quality rearing to take place. Now, the children of this clerk of mine cannot anymore be cared for because they are too many. Is she now violating her duty under the third sentence of the Constitution under Section 12, Article 2?
The presumption, if I may, Your Honor, the presumption of the question is that it's the duty of the woman, whereas Section 12 really refers to the duty of the state.
The duty of the natural, again, read it again, please. The natural right and duty of the parents, first, in the rearing, will be supported by the state.
Yes.
So to whom
Yes,
is the right and duty? To whom does it belong? The parents. Then, in the pursuit of that right and duty, the state shall support the parents. That's the
Yes.
order of things.
Yes, Your Honor.
Okay. In which case, basically, you are saying that the woman who is receiving only 10,000 pesos a month and whose husband probably does not earn so much is now required to put her life at peril in order to ensure that any fertilized ovum that results from a sexual act with a husband is not prevented from being implanted in her womb, even if it endangers her life, and even if an additional child will effectively prevent her from exercising her right and her duty. You're saying that?
If Your Honor, please, the presumption is there are no other available family planning methods except for contraceptives. But there are other family planning methods which will not harm the life of the mother and the life of the unborn. So in that case, both of their lives will be equally protected. And, I think that woman should be prudently advised to consider other methods other than contraceptives that will, achieve what she wants or will address her problems, but not endanger her life as well as endanger the life of the unborn.
At home, and many of our employees are in this situation, lives in Fairview. When she gets to Fairview, it is already 8 o'clock. Pagod na. The only time that she can see her husband will be a few hours. And then, in order to follow the natural family planning, she uses the tulak system. Okay? Tulak system, you push your husband away. Is that promotive of the first sentence of Section 12? What will happen? What will happen? And let's be frank about it. Will the husband appreciate a woman who pushes his wife, who pushes him away?
Well, if the husband is considerate enough, then, and probably it's how the woman makes the tulak, then...
A tulak is a tulak. Huh?
Well, I think, if I may say this, Your Honor, the first sentence is so much deeper than that. I mean, I think it's when you say the sanctity of family life and strengthen the family, it's not just based on that aspect of the married
sanctity of
life.
family life requires that both partners in such a marital relationship have the means to explore each other as husband and wife. That is how I understand it from a practical point of view.
Yes, probably, if Your Honor,
Yes.
please, that's a practical point of view, but
Okay.
I think that's
In
not...
other words, what I understand is, you have set a very inordinately high bar for every woman to grapple with her conscience under such economic conditions without giving a way out for her in this situation. You see, the kind of advice I could actually be giving would be the advice that many of us would be giving our employees whom we are already seeing are in dire poverty conditions. They are not born out of a desire to violate the Constitution, but they are born out of a desire to be compassionate to the conditions of those who are living in such situations.
If Your Honor, please, I'm setting the high bar insofar as the state is concerned, because it's the state's duty to address poverty, and it's the state's duty to provide jobs.
All right. So we go again. Do you believe that we are supposed to read the provisions of the Constitution in balance and not isolate one sentence as against the three
Yes, Your
sentences in
Honor.
a section and one section against the other sections? Okay, I'll ask you to go again to another provision of the Constitution. You go to section 9 of the same declaration. Okay, can you read section 9, article 2?
The state shall promote a just and dynamic social order that will ensure the prosperity and independence of the nation and free the people from poverty through policies that provide adequate social services, promote full employment, a rising standard of living, and an improved quality of life for all.
Okay. Now, can this be done in a year?
Depends on the program, Your Honor.
Can this be done in 2 years?
Again, it depends on the program.
Can this be done in 3 years? Has any nation ever accomplished a significant increase in a year?
Increase of?
Well, those standards, those threefold goals of the Constitution, of the economy. Well, what I'm saying is, the complexity of this question could actually be beyond this court to address. First, your argument, and I've read your argument through and through, premises itself solely on statements made by 3 or 4 commissioners in the Constitutional Commission. That's Gascon, Villegas, Davide, and one other perhaps. Okay. Now, in which case, according to the understanding that I'm getting from the drift of Justice Carpio's question, was an extreme reaction to a solution that actually was already found by the fact that Roe versus Wade can never happen in this jurisdiction because of the phraseology of Section 12. Without going to the extreme interpretation that conception immediately, no, not extreme, but at this point it was not then fully debated, that conception starts from the moment of fertilization. In other words, because Roe versus Wade is a situation that was already way into the pregnancy, it can never happen in the Philippines. But in an extreme, where you were saying, in an abundance of caution, some commissioners happen to have made a statement that it starts from fertilization. Then we go back to the question of Justice Peralta. What was the people's interpretation at the time they ratified the Constitution? If you are going to use the tool of contemporaneous construction by the acts of the people, where an overwhelming majority favor the use of modern artificial methods, then that is one way of interpreting how they see the Constitution to be. I don't think that the people will allow that their future be determined only by statements made by 4 people. But you see, the problem that we have is we have to even balance all of these constitutional goals together. And for all you know, the question may not even be before us. You understand the complexity?
Yes, Your Honor.
In other words, what we really want is a more layered approach to your arguments than just making use of these statements of 4 people. We are looking at how we can substitute our own judgment for the judgment of Congress and the judgment of the President that this is the way forward for our people. We are 15 unelected people. Most of us are beyond childbearing years. I'm sorry. Okay. So it would not really hit us personally. But we want to be very clear about our own constitutional duties. Because, okay, there were snide remarks here you can ignore. Because I then have to ask you the question. If artificial contraception had been here, why has it not been criminalized so far?
If Your Honor, please, may I just ask a question regarding the previous point that you raised, Your Honor?
Yes.
You said, I'm getting the impression, if Your Honor, please, is my impression that this court is going to disregard the constitutional intent as expressed by the 4 commissioners? Because they have...
Wait. There is no intention to disregard. But what I'm saying is
because that was what they was agreed upon, Your Honor, as a constitutional intent of this Section 12, Your Honor. It was clearly expressed, and they had impassioned debates on that, Your Honor.
Please listen. I am not disagreeing that those statements are on record. There is no disagreement that those statements are on record. But you are forgetting that we have tools of analysis in order to analyze the Constitution.
Yes,
one
of which...
Wait, please.
I apologize, Your
Okay?
Honor. I apologize, Your Honor.
And what we are asking for is a more layered approach, because this court is not going to decide one case apart from its very complicated context. Nor is this court minded to just pay attention to one sentence above all, and it's not even a full sentence, but it is only half of a sentence as primary over everything else. That is what I'm asking you to listen to. And that is why I'm asking you to help us balance the right to life of the unborn child from the moment of conception with the other constitutional values that I have already tried to bring out when I was discussing the possible concrete scenario of a poor government worker unable to earn decently for her family and wishing that there was a way to stop the proliferation of the number of children that she has. So it's layered. And usually decisions of this court take that into context. You understand that?
Yes, Your Honor.
Because you know why? We are not going to answer a theological question here. We are not going to answer a metaphysical question here. The reason why we cannot answer that is we are more humble than wishing to go into the area of defining ultimate morals. The Constitution has already identified for us the proper metes and bounds of our powers, and we dare not go beyond that. Okay, so we go again to those concrete cases. Are we now in a position to supplant the policy approaches and the decisions of Congress in trying to balance its many constitutional goals? Are we in a position to supplant all of those?
If Your Honor, please, our position is that this RH law makes abortion possible. And of course, that is against our laws, Your Honor. And insofar as Section 12, Article 2 is concerned, it is also our position that the RH law violates Section 2 because of promotion and promotion of contraceptives and the mandate for widespread dissemination and universal access to contraceptives, Your Honor. And
I know your position. I know your position, but you have not answered the question. Are we in a position to supplant the decision of Congress to choose a policy direction, considering the so many interests that have been outlined already in the Declaration of Policies of the RH law? Can we say this is a better way? Are we not limited enough? We are limited, first, because we are unelected, and second, we have already defined metes and bounds.
If Your Honor, please, if there's such a serious assertion of constitutional issue or assertion of unconstitutionality of a law which is present in this
But
case.
the justification is also a constitutional goal. See, that's what the point I have been trying to tell you. We are here trying to balance several constitutional goals. That was the gist of Justice Reyes's questions. Are we a court that can just focus on half of a sentence? Or do we take the whole of the law as it tries to address several policy objectives that are found in the Constitution?
Okay. So far, what I'm getting is that we have this problem. We have the problem of poverty, and we have, the problem about being able to make choices, Your Honor. But we also have to consider that what is involved here also is a more fundamental right, which is the right to life of the unborn. So I think that the balancing of interests will have to be considered very carefully, Your Honor.
Who are we to say that the poverty approach, alleviation approach of government, and the health protection approach of government is superior? Our approach, their approach is inferior to our moral sense.
If Your Honor, the Constitution is breached, then I think this honorable court has the bounden duty to step in and determine the metes and bounds allowed under the Constitution.
Yeah, because again, we have phrased it carefully already. The Constitution does not say from the moment of fertilization. It says from the moment of conception. And the equality paradigm is there. We cannot disregard that equality paradigm. And we look at the first sentence and the third sentence, and it talks of about a whole plan for the family, which we cannot also ignore. In other words, one way the court can approach this issue is to just say that considering that there are so many competing interests here, we are not in a position to make a factual determination of the questions you have been asking us to make.
Well, our position is, with due respect, Your Honor, I mean, this honorable court doesn't have to make a factual decision because that's already been settled by the Constitutional Commission, because the reason for that is really to protect the life of the unborn from the very inception. And if we know already that inception is at the point of fertilization and not at implantation, which is several days after fertilization, then I think, Your Honor,
Noche, I have to remind you, we are here trying to balance many things. You are harking again to your interpretation of the second half of the second sentence of Section 12. Help us. Look at other provisions so that we can come up with the right balance. That is what we are trying to be. We're trying to be very careful about our exercise of our constitutional duty. Here.
If Your Honor, please, I can think of Article 3, Section 1. No person shall be deprived of life, liberty, or property without due process of law.
No.
So, the unborn, as we already know, has the right to life, and that life has to be protected and cannot be taken away without due process. even if we say that.
Now, if you're going to be strictly technical about it, the definition of person under the law is that as defined in the Civil Code. A person is defined as either natural or artificial. A natural person becomes a person only when there is viability. So if you are going to use that, you have a problem, a statutory bar. If you're going to use due process, help us look at other options because we are willing and we are open. What we're trying to tell you here is that we have a very complicated situation.
Well, I don't know what other more compelling reason there is than, protecting the most fundamental among all human rights, Your Honor. And I think, no one can claim to be here, and we will not be, arguing about this issue.
You know why this question is very important for the country? Is because when you're saying that the life of the unborn starts from the moment of fertilization, if our countrymen, especially women, have been using contraceptive pills for decades, you are basically saying that they have been violating the Constitution from 1987. And is it now the province of the court to make a pronouncement that that is so? And is it now our duty to say that Congress has reneged on its duty by not criminalizing the use of contraceptives? You have placed us in a very difficult situation, and we are open to suggestions, but you must provide a constitutionally viable way for this court to address those questions.
If Your Honor, please, what makes this RH law really despicable is it's the state. It's the state that exercises its power, supposedly to promote the common good. And it's supposed to be a parens patriae, the principle of parens patriae. You protect people who are not able to do anything to remedy their situation. And this should also apply to the unborn. And this is what makes it so despicable. It's the state and that's doing this. This is a state-mandated contraception that makes it so despicable, Your Honor.
Let's go to contraception. You have already looked at the IRR and you saw already the natural and artificial modern methods. Modern contraception methods that are enumerated in the IRR. You have gone through that?
Not through all the...
Okay. Let us go to HH. Paragraph HH of 3.01.
HH.
Okay. Okay?
Yes, Your Honor.
Okay, I'll read it for you so that you can collect your thoughts. Modern methods of family planning refers to safe, effective, non-abortive fashioned and legal methods or health products, whether natural or artificial, that are registered with the Food and Drug Administration as applicable to plan pregnancy. Modern natural methods include Billings ovulation or cervical mucus method, basal body temperature, symptothermal method, standardized method, lactational amenorrhea method, and any other method deemed safe, effective, and natural by the DOH. Have you read that?
Yes, Your Honor.
Okay, you have anything against these?
Against the natural?
Yes.
I suppose.
No.
What do you mean? Anything against how it's written?
You will allow and support government's promotion of these natural family planning methods.
I suppose.
Yes?
Yes, Your Honor.
Okay. Modern artificial methods. The following sentence follows. And or health products include oral contraceptive pills. You have said that you say that this is an abortive fashion.
Yes, Your Honor.
Condoms, you have already replied to the question of Justice Bersamin. It's not an abortive fashion.
Yes, Your Honor, it's not.
Injectables.
Abortive fashion, Your Honor.
Intrauterine devices.
Abortive fashion.
No scalpel vasectomy.
It's not abortifacient, but it could be mutilation, Your Honor.
Is it or it could be? What does the revised penal code say about mutilation?
Okay, I was holding it earlier, but I don't have it right
Well,
now.
from
Your Honor.
memory,
It's severing a body part, a reproductive organ or something.
so if you take out that body part, separate it from the person, that's mutilation.
Without any medical reason for doing that, and that may be a mutilation, Your Honor. Without any reason for doing that.
If there is a medical reason,
Well, I suppose it's not mutilation because it's medical surgery.
so mastectomy,
It's-
hysterectomy.
Yeah, there's no problem with that, I suppose, Your Honor.
Mastectomy is all right.
Yes.
Hysterectomy is all right.
Yes.
Even if it results in the loss of a reproductive organ.
If that's medically required, Your Honor.
So the intent is important before it becomes mutilation.
Yes, Your Honor, because if there's no reason to do it.
Does the
and-
revised penal code talk about intent?
Well, for criminal liability to set in, Your Honor, I think it's important to look into intent.
Does the revised penal code require the element of intent?
Unless it's mala per se, Your Honor.
Okay, so you're not ready for this question, but you have characterized it already as mutilation.
I said it may be mutilation, Your Honor.
Under the law, mutilation is a criminal act.
Yes,
So
Your
you're
Honor.
basically saying that one who has a tubal ligation has committed a violation of the revised penal code? So this is basically your legal conclusions from your arguments. One who has already used oral contraception has already violated the Constitution. One who has had a tubal ligation or a vasectomy is already guilty of violating the revised penal code. Are you asking us to make those legal conclusions?
If Your Honor, please, again.
Yes.
If Your Honor, please, again. It's not the individual that violates the Constitution, because it's a state. The state that has the duty to equally protect the life of the mother and the life of the unborn from
Okay.
conception. So, but the question is premised on whether the individual commits a violation of the Constitution by taking contraceptives. That's not our position, Your Honor. We're questioning Section 12 based on the RH law, and the RH law is the state imposing contraception.
There is no duty on the part of any individual, not even by a Supreme Court justice, to promote only natural family planning methods. It is only the state that is bound. That is your theory?
The state is bound.
No, question. There is no individual duty on the part of any Filipino, including of the justices of the Supreme Court, to promote only natural family
No
planning
duty,
methods.
Your Honor.
No duty.
Yes.
It is only the state who has a duty to not promote any method other than a natural family planning method.
I did not say that, Your Honor. Any method that's going to put the life of the unborn at risk, Your Honor. That's the position
So
that
we
are
go to
taking, Your Honor.
condom is all right. A vaginal cup,
yes, I suppose.
a spermicidal. It's not only Justice Bersamin who knows some of these things. A spermicidal, you have already considered, is not an abortifacient?
Yes, if it prevents fertilization, then it's contraceptive and not abortive.
Okay, so it is all right for you, for the state to distribute condoms. Okay?
Under the provision.
Yes, no.
Yes.
Okay.
That's under the
It is
provision,
all
Your
right
Honor.
for you, for the state to distribute vaginal caps.
Yes, Your Honor.
It is all right for you, for the state to distribute spermicidals.
I have to be very honest. I'm not too sure about.
But you
the
should
nature
have,
and
because you're going to
spermicidal.
describe all of these methods to us, because we have a lot of questions in our
Yes.
mind.
I can make a general statement. Those that.
Okay, oral contraceptive
prevent.
pill. Okay. You know that many women right now, even those who are young, in their teens, have the phenomenon called PCOS. You know what PCOS is? Okay. PCOS, it's not a machine. It's the polycystic ovarian syndrome.
Okay.
Okay? In that situation, there are many cysts that are lining the uterine wall.
Yes, Your Honor.
You know what the medical response to a PCOS situation is? Other than surgery, what is it?
To take the pills.
Correct.
Yes.
So there is a medical reason
There's a medical
for
reason.
this.
Yes, Your Honor.
Okay.
But
Is that therefore prohibited?
no, Your Honor, because usually that's upon advice and disposed upon prescription of a duly licensed physician. So it's monitored, and there's a therapeutic reason, a medical reason for doing it.
So, those medicines that prevent the ovum fertilized from being implanted in the womb are not by themselves prohibited if they serve a medical reason.
Yes, Your Honor. Yes.
But I thought that you said that the primacy of everything is to make sure that the fertilized ovum has a receptacle in the form of and it's a positive duty to make sure that there is nothing that prevents a healthy implantation.
If Your Honor, please, if that medical reason is determined by a physician who supervises the giving, the prescribing
if a physician
of that.
says that the health of my employee is already endangered because if she has additional pregnancies, can that physician prescribe an oral contraceptive pill?
If it's is there a medical reason? I'm sorry.
Her health is deteriorating. Obviously, she cannot bear more.
Just deteriorating, but there's no specific medical reason for
Poor health, little nourishment. She cannot bear anymore to have children. And that's the condition of many Filipino women. Okay, you are pausing. That gives you a puzzle. That's the reason why I was telling you our situation is complicated and you have to allow us to ask you in a context-layered way and not be shocked at the fact that we are trying to ask questions from a multi-angled perspective.
Yes.
You understand?
Your Honor, I was just reading something, that's why I paused.
Well, you were pausing even before you read it. So, let me now go to a different situation. Infertility. Okay? They go to a fertility clinic and an egg is fertilized with the sperm of the husband. Okay? Assuming that during that menstrual cycle, 2 eggs were extracted. 2. And 2 were equally put in a petri dish. Or even 3. Because the woman took fertility pill. And even 8. Because that is the most number of births that have ever been given in one delivery. 8 eggs. All of those eggs were implanted. And because the man seemed to be at his peak at the time when he was extracted with the sperm, all 8 were successfully fertilized. Okay? Is there a duty to implant all 8 on the woman?
Okay, if Your Honor, please, so sure, there are ova formed already, because so those are persons already, Your Honor. And that's something I've been reading up on this, Your Honor, and that's something that is quite troubling, Your Honor, because what do you do with the rest that will not be implanted, Your Honor?
Yes, that's the question I'm asking you.
Exactly, Your Honor.
Is it a duty to implant all of those 8 on the woman's womb?
I don't know the medical implications on the woman if, all the 8 are going to be implanted there. But then all of those 8 are persons, and, I think also the lives of the 8,
is there a duty?
will also have to be considered.
Yes, you have to think about whether we can force a woman to receive 8 fertilized eggs. Does a woman have a duty to receive 8 fertilized eggs?
If Your Honor, please, the woman didn't have to get into this situation if she knew exactly what to expect before undergoing this procedure.
She is infertile. She is infertile. And there is always a chance that even with the harvest of the eggs, not all attempts will succeed. They have been trying years and years
Yes,
and years.
precisely.
So she took a fertility pill, 8 eggs were produced, and it has happened.
So
8 were planted on a petri dish. 8 were successfully fertilized. If you are saying that there is a constitutional duty to ensure that there is a receptacle or a womb for life to be viable, for every fertilized ovum, is there now a duty on the part of the woman to allow herself to be compelled to accept 8 fertilized eggs?
Let me look at it this way, Your Honor. What are the interests involved here? The interest of the woman to get pregnant. Okay? The other competing interests here are the lives of 8 human individuals, human persons. So, I guess the answer should be very clear that the lives of the 8 persons we have to ensure that the lives of the 8 persons are protected and preserved, Your Honor.
So between
compared to the choice of the woman.
So there is therefore no equality balancing. The equality word in the second sentence of Section 12 does not mean anything. We're basically saying the primacy of the right of a fertilized ovum to be implanted in a womb is primary and supersedes any other right existing.
It's not that, Your Honor. As Father Berna said, it's not really of equal importance. No? I mean that the way it is read is that the life of the mother and the life of the unborn shall be equally protected. So it's not like they both stand on the same ground or same footing. But when instances are such
that's a theoretical statement. I'm asking you a concrete statement. It's not easy to survive a pregnancy with 8 ova inside a womb. Does she have absolutely no right to ensure that she survives?
That she
survives.
The woman survives?
The woman. In other words, are we now saying that the equality spoken of here in the second sentence does not at all have any meaning?
Is it proven that she will not survive if all 8 are implanted, Your Honor?
You see, this is the reason. So she has the burden of proving that she will not survive?
Yes, Your Honor, because all the 8.
She does not even have the right to say, I cannot and will not bear 8 children?
I don't think she has the right to say that to the detriment and to the great prejudice of the 8 human individuals, Your Honor. These are lives that we're talking about, human lives. So, if Your Honor, please, I think we have to be very clear about what Section 12 really protects here.
Okay, so this is what is really before us. The questions that are concrete that I have given you, you have found difficulty answering. The legal statements you have made here as your basis for your petition are statements made outside of a concrete context. Congress has already made a decision, a policy choice. We cannot receive factual evidence.
I was hoping, Your Honor, that this court would take judicial notice of extensive medical findings and medical journals
But these are
and textbooks, Your
all
Honor.
conflicting. The reason why I'm posing these difficult questions for you is because we, as justices of the Supreme Court, have to look at those possibilities. We do not decide in a vacuum. We try to anticipate for the future.
If, Your Honor, please, this honorable court has in the past made exceptions, Your Honor, to technical rules of procedure in order to...
No, these are not technical rules of procedure even. The questions of Justice Leonen are technical. Mine is basically a substantive duty on the part of this court to always ensure a balancing of interests. That's why I'm asking you for help in balancing the interests that are before us. What does not help us in the way we need to balance interests here are general statements alone. That's why we test your theory by giving you concrete situations that you need to respond to. And by your responses, it is clear that even you are grappling with these questions because these are very difficult questions, which seems to indicate to us that maybe this court is not the best forum, but this court might need to exercise judicial restraint unless you can show us a constitutional way out of our jumping in the situation and substituting our judgment for that of the Congress and the executive combined. See, we are not closing our minds to anything, but you have to provide the court these tools, because these tools are quite limited to us.
If Your Honor, please, it's not a matter, I think, of this court substituting the judgment of Congress or the executive. I think it's for this court to uphold the supremacy of the Constitution at all times, Your Honor.
We are always trying to do that. Mind you, that's why my question is even in the way I give an advice to my clerk, I am mindful of what the Constitution is saying. That's why I'm asking you, am I already violating the constitutional principle of upholding life from the moment of conception? See, they are not theoretical. They are very concrete, live situations that we ourselves apply to our own day-to-day decisions in our attempt to give fealty to the Constitution. That's why I ask you those specific questions.
But if Your Honor, please, if the Constitutional Commission has already made it clear that the intention is not to leave it to Congress to determine when the beginning of life is,
but you see,
and we Your Honor is not prepared to accept that conception is fertilization, if that's what I get, and you still want to leave it to Congress to determine when human life begins, then I think I will really have difficulty answering your questions, Your Honor.
One problem you have in your petitions is you have not used and shown to us with sufficient clarity that the statements made by the Constitutional Commission by 4 members is determinative, finally, of the question. You see, there are contemporaneous construction materials we need to use. We need to look at the context of the Constitution, and we have to balance this. That is why I was trying to draw out things from you. Please note, I have always been telling you that we are open. But our duty is more nuanced than what you want us to respond to you immediately. And in fact, my questions are basically intended to help you also. Because for all you know, you might be able to draw upon my questions and submit a richer memorandum than you thought was possible.
I realize
Do not take offense at this. We are not here to try to pin you to only one position. We are trying to test the validity of your arguments.
If Your Honor, please, I beg to disagree that what I have pointed out are just opinions of 4 members of the Constitutional Commission. They were the most active members who debated on this and who participated in the debates, but it doesn't mean that these are their opinion. This was put to a vote, Your Honor, and it's in our reply, Your Honor, how the voting went. So this is the constitutional intent, not just of 4 members of the Constitutional Commission, but of the 1986 Constitutional Commission itself, Your Honor. And if that doesn't warrant the consideration of this honorable court, then we will be it will be very difficult for us to look for other
We never said
support.
We never said we will not consider it. We never said that. None of us ever said that.
Yes,
but
Your
we
Honor,
have been actually trying to draw from you other sources.
Yes, Your
other
Honor.
sources, because you understand that from the very beginning of law school, you are already given a list of the primary sources of law, then you are given tools of interpretation, then you have your lesson on constitutional construction, then you have your lessons on contract interpretation. These are all logical and analytical tools, and that is why I'm trying to draw you. This is to help you, actually. Okay, now, let me now go to another point. Okay. The Justice Velasco has already tried to create a situation where some provisions of the RH law can stand constitutional scrutiny and others cannot. You have, however, said that the law absolutely cannot stand scrutiny. He was saying that the principles that are found all over in many extant provisions of the law itself talk strongly against the use of abortive fashions. Can that not save some provisions of the law, while the others we may be open to striking down? He asked you a fair question, and you said, absolutely not. Now, this is also actually an opening for you to respond in a more broad-minded way when you are already being asked by a justice to make the refined distinctions between sections. What are the most obnoxious sections, and what are the sections that you are willing can be considered as capable of standing constitutional scrutiny? That was actually his question. So would you like to review your answer in that?
Now, Your Honor?
Yes, you're supposed to be an expert on this. That's why you're counsel here.
Yes. As I said, Your Honor, and insofar as hormonal contraceptives are concerned, Your Honor, we have said that they're abortive fashions, Your Honor, unless the present available contraceptives in the market, they've been found to be abortive fashions, Your Honor, and have an abortive character, Your Honor.
You're basically saying that oral contraceptives are abortive fashions because there is nothing in the market that does not have the quality of the safety net, which is the rejection by the womb of the ovum, fertilized ovum that is trying to be implanted.
Yes.
If that third action is not there, and there is a contraceptive pill that only talks of the first two actions, are you willing to consider oral contraceptive pills?
If there is such a contraceptive, yes.
Okay. So you are willing to concede that, and are you not willing to concede that the phraseology of Section 9, Section 7, that says that the FDA is hereby authorized to certify that they are not to be for abortive fashion use, that is not sufficient for you as a safeguard? In other words, we are not foreclosing the possibility that there are oral contraceptives with the first two actions, without the third action, and the FDA will certify that. Is that not a sufficient safeguard?
May I just point out something, Your Honor? We have a problem there, Your Honor, because if the standard use is that life begins at implantation, then I think that really is completely divergent from Section 12, Article 2, as we espouse it to mean, Your Honor, which is conception equals, is fertilization, which is the beginning of life. And then if we look at the definition of abortifacient in the RH law, and also look at the implementing rules and regulations, there is a radical difference in the definition, because in the IRR, Your Honor, they have inserted the word primarily, Your Honor. When you say...
Okay, let's just focus on the law, because that's what you are bringing before us. Let's take it as a problem, the IRR, later. The Justice Velasco's question again, the law alone.
Yes, Your Honor.
Same question. Can you review your answer, please?
Okay, so hormonal okay, if the matter is referred to the FDA for proper determination, I think there was a question earlier. I said if there's a basic agreement that life begins at fertilization, then probably FDA can determine whether a contraceptive is abortifacient or not. But then if the standards are different, that life begins at implantation, then we have a basic difference there, Your Honor.
So the law itself, the RH law, apart from the IRR, has not changed the definition, and you're acceptable. You accept the definitions in the law.
Of abortifacient, Your Honor? Yes, Your
Okay.
Honor.
So definition of abortifacient under the law is acceptable to you.
Yes, Your
So
Honor.
it's the IRR that you have a problem with.
Yes, Your
Okay.
Honor.
Fellow justices, I have no more questions for the first round. I'll turn over the microphone to Justice Carpio.
Counsel, does the RH law define when conception occurs?
No.
It does
The
not.
RH law?
Yes.
No.
Does the RH law safeguard that the fertilized ovum will reach the womb of the mother?
Safeguard that it will reach.
Is the policy of the RH law to ensure that the fertilized ovum will be implanted on the womb?
There is no such policy. Well, it says.
What does it? It says that the state guarantees to distribute methods, devices, supplies which do not prevent the implantation of a fertilized ovum as determined by the FDA. So the policy is to ensure or to safeguard that the fertilized ovum will reach the wall of the uterus, correct? That's the policy of the law, correct?
Yes.
And the law, in fact, says any drug device that has the effect of preventing the implantation of the fertilized ovum is the same as abortion because they are called, what do you call it? Abortifacient.
Abortifacient.
So the policy is, in fact, to ensure that the fertilized ovum will reach the womb of the mother, correct? That's the policy of the law. Correct?
Well, that's the textual policy of the law.
The text says that. So
yes.
we have to go by the text, correct?
Yes.
Okay. So the law does not say that life starts at implantation because the law in fact protects the travel of the fertilized ovum to the mother's womb, correct? The law, if you look at the law, it repeats and repeats that to anything that the government shall not distribute anything that prevents the fertilized ovum from reaching the wall of the uterus, correct? That prevents implantation. That's
again,
the policy.
Textually,
that's the text.
Yes, that's a text.
So there is no conflict between your definition of conception and the definition of conception as implied, as textually implied in the law. Because the law protects the travel of the fertilized ovum to the uterus.
Yes.
So there is no difference. The law, the intention of the law is the same as your intention, that life begins at fertilization, correct?
Okay. Put down, no? as written down in the law.
Yes, as written down in the law, and we have to decide whether the law is constitutional as it is written, correct?
Not when certain ambiguities arise because of certain phrases written all over the law.
Certain ambiguities. What are these?
Okay, the phrase we mentioned in Section 9, the hormonal hormonal contraceptives that may be used as abortifacients.
But
and when the law, yes, Your Honor,
Go ahead.
and when the law mandates the purchase, distribution, and use of hormonal contraceptives, which are abortifacients in which the law admits have abortive capacity and can be used as abortifacients, then we begin to read the law more closely, Your
That
Honor.
will still be determined by the FDA, as determined by the Food and Drug Administration. We cannot determine whether this drug will prevent the travel of the fertilized ovum to the wall. We cannot do that. You
Yes.
have to start at the FDA before you reach here. We have to look at the law, and the law says it becomes unlawful if it prevents the implantation of the fertilized ovum on the wall, as determined by the FDA. You have not shown that. Where is the certification of the FDA? There's none. You're jumping the gun. You have come here on the assumption that all of this will prevent the fertilized ovum from reaching the wall of the uterus.
Because that's the very nature of abortifacient, Your Honor.
Yes, but the drug may or may not. We don't know. That's why you first go to the FDA and test that drug and come here if you don't agree. Because you cannot just come here and say all of these drugs violate the Constitution. Because it turns out that this law has the same intention as your definition of life.
But not
the law protects the travel of the fertilized ovum to the wall of the uterus.
If
you
Your Honor,
admit that textually.
textually, Your Honor, but then I suppose legislative intent may also be determined according to Bayan versus Comelec from extraneous sources. And when the proponents, most active proponents of the law, like Representative Lagman, begin to say that life begins at implantation, there's no life at fertilization, then I guess it's something that we need to look into very seriously, Your Honor.
Lagman said, I do not find it in the law. I look at the law and do not read the law with what Congressman Galgaman said.
No,
he said that it's not in the law, and I do not consider that.
Yes, Your Honor, but it's also, but we can also consider the legislative intent, considering all these contradictions in the law, Your Honor.
Okay, so
we
let's
have
be
to look
clarified
at the
here.
legislative
Let's be
intent.
clarified. Textually, the law does not say that life starts at implantation. Correct?
Yes.
Textually, the law says that the fertilized ovums travel to the uterus shall be safeguarded. Correct?
Yes. If Your Honor, please, no, when the law advocates or mandates the purchase of contraceptives, then you begin to...
No. The law says the state shall distribute devices, drug supplies, which do not prevent the implantation of the fertilized ovum on the uterus. The law says that.
Do not, but the law also mandates...
Okay, do you agree that the law says the state guarantees universal access to methods, devices, supplies, which do not prevent the implantation of a fertilized ovum as determined by FDA? The law says that, correct?
Yes, Your Honor.
So what does it mean? The law says the government will distribute only drug supplies and devices that do not prevent the implantation of fertilized ovum on the uterus. So it protects the travel of the fertilized ovum to the uterus, correct?
Textually, yes.
So there's no difference between your concept of your definition of conception and the law's intention to protect life at conception upon fertilization of the ovum, correct? You want to protect the fertilized ovum's travel to the uterus. That is the intention of the law, correct?
Yes. Well, that is that's what's stated in the Declaration of Policy, Your Honor.
Yes, that is the textual meaning of the law.
But I would say that that's contradicted by the other provisions which mandate purchase of hormonal contraceptives, which are abortifacient.
What is that section?
Okay, let me just look. when the law says, okay, it's all over actually. It's page, what page is this? D,
Section.
section 2D, second paragraph. The state likewise guarantees universal access to medically safe, although it says non-abortifacient, effective, legal, affordable, and quality reproductive health care services, which do not prevent implantation of a fertilized ovum.
Yes.
As
it says-
determined.
yeah.
Yes, okay.
So, in other words, it must not prevent the implantation of the fertilized ovum. Now, if there is a drug that prevents, and the FDA certifies it does not, you can come to us. But not now. There's no controversy here. You agree with the intention of the textually the law says that life is protected at fertilization. That is your position. That is the position of the law. Then why are you here?
Because, Your Honor, there's a basic there's certain provisions have created ambiguities. While if you look
Yes,
at
what is that provision? Point out to me the specific provision.
Yes, Your Honor. Okay, Your Honor. The Section 9. Section 9, Your Honor, it says, for the purpose of this act, so I suppose that refers to the law, any product or supply included or to be included in the essential drugs list must have a certification from the FDA that said product and supply is made available on the condition that it is not to be used as an abortifacient.
What
So it's
section are you referring?
Section 9, Your Honor.
What's the title?
Okay. The Philippine National Drug Formulary System and Family Planning Supplies.
Where does it, so you're referring to the last sentence of the first paragraph?
Yes.
Okay,
Yes,
go ahead.
Your Honor.
For the purpose of this act, any product or supply included or to be included in the EDL must have a certification from FDA that said production and supply is made available on the condition that it is not to be used as an abortifacient. What's wrong with that?
So how will FDA be able to certify that it's not going to be used as an abortifacient? FDA will not be able to go after each and every citizen, every woman, to make sure that she doesn't use it as abortifacient, Your Honor. We quite do not understand that, Your Honor. And then that is also repeated.
It probably means that FDA will test the drug, correct? And see if it is it will prevent the implantation of the fertilized ovum on the wall.
No, but it says here, it gives the impression that it, even if it's an abortifacient, it may still be distributed, provided it's not used as an abortifacient.
No. That's not how I read it. If that is only your objection, I don't think you will get by. Are you saying that because of this sentence, the law is unconstitutional? Is that what you mean?
Not only that, Your Honor.
Yeah, but I don't see here a statement that the FDA can distribute a drug that prevents the implantation of the fertilized ovum on the wall. There's nothing here that says that.
But that's the implication, Your Honor, when it says it is going to be made available on the condition that it is not to be used as an abortifacient. So it gives the impression that it may be
because there
made
are
available.
drugs that can be used. There are several drugs that are multi-purpose or may have a byproduct side effect as an abortifacient. And that's the meaning of this. It doesn't mean that they will actively distribute products that will cause abortion.
So again, I mean, we're
I
trying...
mean, if this is what you're pointing us as the provision in the law that will make it unconstitutional, I think it's very weak. What else? What are the other provisions?
Okay. So, Section 7, all accredited public health facilities shall provide a full range of modern family planning methods. It shall also, well, a full range refers to, this should include hormonal contraceptives and IUDs.
So you're saying that because of the phrase full range, the law is unconstitutional. Is that what you're saying?
Because that thought, Your Honor, is all over the RH law.
Okay, what else? What are the other provisions?
Well, here, reproductive health care, in the
What section?
definition. In the definition, Your Honor, that's Q, 4Q. Reproductive health care refers to the access to a full range of methods, facilities, services, and supplies. And this should also include the hormonal contraceptives.
So when
it's reproductive health care.
So whenever you see the phrase full range of methods, for you it includes
yes, Your Honor.
abortifacients.
Yes, because they should also refer to hormonal contraceptives and IUDs.
Okay, what else?
Well, when you talk of family planning, also letter E.
What section?
I think it's the same section. Section
QI? L?
Section 4E. Section 4E.
Family planning. So what's wrong with this?
And to have access to a full range of
Full
safe,
range.
Well, they
Okay.
say safe, affordable, effective, non-abortifacient.
Okay, it says non-abortifacient.
Yeah,
It's
but then
still
again, if you
objectionable? It's still objectionable to you?
it's a contradiction, Your Honor. If you refer to a full range of family planning methods, necessarily that will include hormonal contraceptives. Then how
So
can
if
that
we say
be
that the full range,
non-abortifacient?
that the meaning of full range, because of the word here, non-abortifacient, does not include any abortifacient device, drug, or supply. That's okay with you? We will
as
say in
long
our
as-
decision that the full range means that does not include abortifacient drug supplies and devices. That's okay with you?
So as long as the full range doesn't refer to hormonal contraceptives and IUDs,
No, non-abortifacient. Because we cannot say that this drug causes abortion or not. We don't have that knowledge right now. We don't have that competence. You have to start at FDA. Prove it there. All we can say is anything that causes abortion will not be allowed. That's the only thing we can say. So we will say that the full range of safe and so on does not include drugs or supplies that causes abortion. That's okay?
yes, so
That's okay with you?
and then leaving
As
it to
determined
FDA
by
to
FDA.
determine.
Okay. Because the law already said it should not cause abortion, non-abortifacient. So that full range does not include anything that causes abortion, by definition, in the law. Okay, what else? What other provision?
So there's a repetition again of provision of, well, it says ethical, medically. I'm referring to section D, 4.
4D.
Then again, third line, reproductive health care services and supplies. So when you talk of reproductive health care and supplies, then you're talking of a full range of.
So we will say it does not include anything that causes abortion. That's okay with you?
But then the problem there, Your Honor, is that includes hormonal contraceptives and IUDs, which, like IUDs, I suppose,
Yes,
Your
but
Honor.
we cannot determine that here. We will have to let the FDA determine that, and then we can review it. You cannot just come here and say that this device causes abortion. We don't know. You have to start at the FDA.
There's extensive documentation to that effect,
Yes,
Your
but
Honor.
you cannot present that here. You start with the trial court.
Well, by that time, Your Honor, a lot of
but that is-
unborn will have been
but we don't
protected,
have
Your Honor.
Evidence
Will
to
not have
receive.
been
We
protected.
don't have jurisdiction to receive evidence here.
But then again, if Your Honor, please, we
In
can
other
always.
words, if you want us to do that, then you are admitting that you have come here prematurely. You have not filed your case at the proper court.
If Your Honor, please, if we did that, and this is also accepted in the case of North Cotabato, in the concurring opinion of Chief Justice Puno, when he said, delayed rendition of
Yes,
justice.
But we do not have, we are not doctors, we are not technologists here, and you want us to accept evidence directly.
If Your Honor, please, there have been a lot of instances in the past when technical rules of procedure have been waived by the court in order to, render justice immediately, Your Honor. And since we're coming here, asserting, Your Honor, that right to life is at stake here, then we are hoping that would be taken into consideration very seriously by this honorable court.
Okay, let's proceed, counsel. What other provisions? Okay, counsel, just put it in a memorandum form. Include it in your memorandum.
Yes, Your Honor, we'll do that. We'll do that.
Okay, that's all. Thank you.
With all my apologies to Justice Bernabe, you may ask your question now.
Attorney Noche, many questions have been asked and answered already, but I would just like to summarize your stand and ask few questions.
Yes, Your
Now,
Honor.
you said in your earlier statement that contraceptives prevent fertilization. Contraceptives prevent fertilization.
That's one of the mechanisms of action, Your
Okay,
Honor.
and at this point, we have no problem because there is no life to protect.
Yes, Your Honor.
Now, when these contraceptive pills fail, then we have a problem because fertilization arises.
It may take place. It may take
and
place.
you said that now we have a problem about the implantation of the fertilized ovum in the uterus because of the abortive effects of these contraceptives.
Yes, Your Honor.
Okay. Now, you have not, of course, given sufficient and conclusive evidence that these contraceptives, hormonal, that prevent implantation, there is none. You mentioned about the journals, but of course these are not conclusive evidence.
Yeah, these journals are all saying that, of course there's hypothetical basis that implantation is inhibited. They're all recognizing that there is this effect on the endometrium which inhibits implantation, Your Honor.
Okay, and neither have you presented sufficient and conclusive evidence also that these pills and devices are carcinogenic drugs.
Again, Your Honor, those are extensively documented, Your Honor, and we have cited the journals, Your Honor, where this could be found, where the findings would be found, Your Honor, in our petition, in our reply to consolidated comment, Your Honor, which
and of course,
we hope would be taken into consideration by this honorable court.
Of course, you will agree with me that these are not conclusive evidence, right?
Even the WHO, as the International Agency for Research on Cancer, has brought out these findings, Your Honor. There's extensive documentation on this. Of course, somebody can always come up, especially those probably that have an interest, to protect insofar as, dissemination or marketing of these drugs are concerned, will prefer evidence to the contrary, Your Honor. But that doesn't detract from the fact that there's extensive evidence, Your Honor, of the adverse effects and the abortive nature of contraceptives. And again, we come to this court hoping that this would be taken into consideration by this honorable court, considering that a very fundamental right is involved, Your Honor.
Okay. You also said that we cannot separate contraceptives from abortives.
Yes.
And there is no guarantee that these contraceptives will not have any abortive effect.
Yes, Your Honor.
And you have not also established that conclusively. Other than the evidence that you are mentioning.
Well, again, extensive documentation of this in journals, and medical textbooks have referred to this, Your Honor. It's not like when you take a contraceptive, you can stop it from taking effect at any point. So it's both contraceptive and abortive, and this are established in medical textbooks and also in medical journals, which have been cited extensively in our pleadings, Your Honor.
Now, when you say abortive effect, what do you exactly mean? Does
may
abortion
cause
have to arise, or it is enough that the harmful effects are there?
The harmful effects are there. It may prevent the fertilized ovum from reaching the uterus, or if it is able to reach the uterus, it's not able to implant, and it's very important for it to implant. And so it's not just the death of the fertilized ovum that we are referring to, because the protection under Section 12 will be rendered meaningless if we only just refer to the death of ovum or embryo. So we also refer to any harm, any risk or threat of harm or injury of any form or degree, whether remote.
If you're not amenable to any of the artificial hormonal contraceptives, then what alternatives would you have to prevent unwanted pregnancies or to control birth?
To control?
Yeah, as a mode of controlling birth control. I mean, apart from the artificial methods, hormonal methods of contraceptives, then what other alternatives would you suggest?
I guess practicing...
Apart from the natural family planning or fertility awareness.
Practicing virtues, which may be old-fashioned by now, but I suppose that will always be there as an option, Your Honor. May not be practical, but I suppose it's something that may be considered. And, of course, other safe methods, Your Honor. Natural family planning method may be one of them. Exercising self-discipline, but for the state to be spending billions of pesos to bombard the population with these contraceptives, which scientific findings have said are abortive and adverse, then we do not really subscribe to that, Your Honor.
But you would agree that these are not reliable methods considering the growth of our population?
Contraceptives also have not been proven to be effective, Your Honor. Since the 1960s, 1970s, with the creation of POPCOM, the USAID pumped in a lot of, hundreds of thousands of dollars, but still, our population is like this. So nobody can also say for sure that contraception is going to be effective.
But would it not be because of the failure of disseminating proper information?
What do you mean, Your Honor?
Information on the programs and services on reproductive health.
So you're saying that it will not be...
It might improve. You're saying that it did not work, the contraceptives did not work even in the past.
Yes.
But with this dissemination, with the programs and services on reproductive health, under this reproductive health law, don't you think this would be an effective way of regulating birth control?
Nobody really can say that for sure, but then what I can say, and I think this is a surer way of doing it, will be to spend the 3 billion pesos on, social services and infrastructure and making sure, there are more jobs, and these are more direct ways of, addressing poverty and rising population or population growth, if that's what really the government wants to do. So, but contraception has its negative effects. I mean, I will have to mention demographic winter in other countries. It's an aging population, and they're now trying to reverse it, but because of, nature, people are now beyond reproductive age, so they cannot bear children anymore now that they want more people, so that there's younger labor force. I mean, these are the effects that need to be considered very carefully. Plus, it has also been shown that economic growth is bolstered by a growing population. So,
and your fear is the perceived abortifacient feature of the law.
Yes, the abortive nature, and of course the money that's going to be spent for that, with it's not really going to be sure to address the problem that it's supposed to address. And not only that, the harmful effects on women of these contraceptives. Why spend something and make something a policy if it's not really going to promote the common good? If it's only going to serve interests of some, it has already been proven in the past, contraception didn't really work. But if you put it in something more concrete, something that you can really see, trying to improve healthcare facilities, which is in the RH law, and I will have to admit that that's a very good provision. Improve Medicare facilities, provide prenatal care to women, and then also skilled birth attendance on women. These have been proven to have worked. I mean, they say maternal mortality, but then there is a province, a place in Catarman, Sorsogon, where there was a zero mortality because, the local government, implemented this skilled birth attendance and provided, prenatal care and obstetric care to women and children. So these are alternatives that will have to be looked into, rather than this that, not only have adverse effects on women or on people, but then harm the life of the unborn. which the state mandates, which the Constitution mandates for the state to protect. So this is our basic objection here, Your Honor.
So you think that the disbursement of public funds for the purpose of implementing this law will not do any good?
Yes, Your Honor. It will do more harm. It will do harm.
It will not promote
It will
general
not. It will
welfare.
not. Yeah. It
of
will
the
not
country.
promote the general welfare, Your Honor, and it's not going to address the problems that the RH law says it addresses.
Okay. Thank you, Counsel.
Thank you, Your Honor.
Justice Abad first, whose second round turn has been quite deferred. Okay, he has very graciously agreed to Justice Pepe.
Fundamental question. It looks from the drift of your answer to the questions of Justice Bernabe that you are now addressing the wisdom of the law. And of course, that is not our territory. That is the territory of the legislature. Let me finish. It will help you. The fact that the law allows the prevention of fertilization is not that what you are complaining about. The fact that the government itself is propagating, putting in money in order to allow the prevention of fertilization is not that which is constitutionally objectionable?
It's also objectionable, Your Honor, because that prevents, that's a birth control measure.
All right. So you are saying that birth control is, you are abandoning the position that birth control is subject to constitutional objections? You're saying it's good? You're saying it's...
No, I don't.
Okay.
I'm not saying it's good.
You.
I'm not saying it's good, Your Honor.
That's what I'm suggesting. That's what I'm telling you. Your strongest point is to go or to question the constitutionality of the basic objective of the reproductive law. And that is, I am getting this drift from the opening statement of Senator Tatad, that this is a population control or a birth control measure. And that is what is constitutionally objectionable. That is your strong point, rather than the point of implantation, etc. The fact that the law allows, not just allows, propagates, makes it a government policy to prevent fertilization, that is objectionable. I suggest, or I would tell you.
Yes, Your Honor, we will include that in the memorandum.
Justice Abad.
Constitutional basis for that argument. Actually, this law is an exercise of police power, in a sense, actually, because it governs, it regulates human conduct, prescribes certain actions. So it's an exercise of police power. And the rule in police power is that first there must be a proper subject of regulation. Not everything in this world can be subject of regulation. For example, my choice of my wife, who will be my wife, cannot be subject of government regulation. So there are things that usually the ones that are subject to regulation or exercise of police power, those that refer to human behavior, like criminal laws. They are to prevent men from committing crimes or to punish them when they commit crimes, or those concerning traffic laws, or a lot of human behavior. But is nature, altering nature, a proper subject of legislation, no? Especially when it refers to birth. We cannot outlaw the storms or the typhoons, because that cannot be done. But we are willing to reduce in a woman, a healthy woman with a healthy ovum or eggs, and we want to give him chemicals that will make those eggs unhealthy, so they cannot be fertilized. We poison the egg to disable it from receiving the sperm that will fertilize it.
Yes.
So we are legislating things that affect the human body in the normal course. We're teaching our people these things. So that's unconstitutional. That's not improper exercise of police power. Don't you think so?
Yes, Your Honor.
I only think it's not something to, it is happening. No? People try to tamper with human life. No, well, we can regulate other things probably, but human life, we tamper with it. If my parents did, when the time I was born, maybe I'll not be here anymore. None of us will be here. If this were so.
Precisely, Your Honor.
That's true. And we are poor. We are land poor. This country is land poor. Actually, we have so many people, they cannot produce enough. Actually, compared to the price of food in Australia, other places where I've been, a lot of the income of people are spent on food because there's no food. We are not able to produce cheap food. So that's one of the problems. So what has saved us, in a way? What has saved us are the people that we produced. The people that became overseas workers and that brought wealth to us. That's what has saved us, actually. So if we want to tamper with that also, we want to remove our capability to have Filipinos born out of the normal course of natural life and tamper with the process that God made for producing life. That I think is not a proper subject. Constitutionally, that's unconstitutional. An improper exercise of police power.
Yes, Your Honor.
Do you agree?
Yes, Your Honor. Yes, Your Honor. Thank you, Your Honor. Yes.
Justice De Castro first.
I will pursue the point raised by Justice Perez. No, I noticed that in the law there is a provision saying that there shall be no demographic or population targets, and that the mitigation, promotion, and/or stabilization of population growth is incidental to the advancement of reproductive health. But in another provision, there is a need to conduct studies to analyze demographic trends, including demographic dividends from sound population policies. So it would seem that the law is intimately connected to population control.
Population control, yes.
And another point, it would seem that the target of this law are the poor and the marginalized. It would seem that the poor should not be, under this law, should not be allowed to multiply, because the supplies and the health care provided by this law is given to the poor as the principal target of this law. I noticed several provisions referring to the poor and the marginalized in the distribution of health care supplies and services.
Yes, Your Honor, that's true.
That's all.
Thank you, Justice De Castro. Justice Leonen.
I also noticed something in the law. This is in Section 3, subparagraph F, number 1. May you read for the record the proviso of number 1?
Section 3.
F, number 1, the proviso, before the number 2.
The state shall promote programs.
No. This is Section 3.
Sorry.
F, number 1,
Section
the proviso.
3F1. Okay. Provided
Yes.
that no one shall be deprived for economic reasons of the rights to have children.
Yes. And then in Section 2, on the declaration of policy,
Section
letter A.
Section 2A.
The right of spouses to found a family in accordance with their religious convictions and the demands of responsible parenthood. And then letter D, the right of family or family associations to participate in the planning and implementation of policies and programs that affect them. The point being that there are provisions here which actually says that this is not a population control bill, and it is not intended to control the number of children of those who are poor or those who are rich. But there are, of course, some provisions, I may admit, that left to their own devices, standing alone, not in the context of the entire statute, can be misinterpreted as saying that this statute is a population control measure. Again, can we go back? What is the presumption that we should give to this statute? Should we give it a presumption of unconstitutionality or a presumption of constitutionality?
Well, there's always that presumption of constitutionality, but it doesn't mean that that presumption may not be demolished.
If the text is clear that there can be an interpretation that will allow those who will finally implement it and create the actual case, that will make it constitutional, is it the function of this court to distrust the political departments or the executive that they will implement it the way that it is supposed to be designed in the implementation with the clear textual provision that, number one, there will be no demographic targets, number two, that there will be no limits to children, number three, that the choice of the family with respect to the kind of family that they will build is up to them based on the religious conviction.
Okay. The textual compliance, Your Honor, is with respect to every provision. But
the question is, should we start with mistrusting the executive and the implementors?
It's not a matter of mistrusting, Your Honor, when there's
therefore
an allegation.
We should afford the presumption of constitutionality,
but then, Your Honor,
we should assume unconstitutionality.
But then, Your Honor, if there's an allegation of a breach of the Constitution, then I think it's the duty of this honorable court to look into allegations and make sure that
but we have been consistent
constitutional
in terms
myths
of
and
our
bounds are
constitutional
established.
Jurisprudence that only when there is a clear and convincing demonstration of a breach of a constitutional provision will we allow the hammer to strike down and strike down heavily. Angara versus Electoral Commission. In this particular case, like many other cases, we have said that in cases where it can be that the political department that will implement it can interpret it the way that is constitutionally feasible, then it is not for us, the judiciary, to actually mistrust them that they will not do what they should do. Perhaps, counsel, the better track might be that maybe you should immediately go to the FDA, find the product, so that immediately it will be stopped in order that if it becomes proven to be an abortifacient, so that lives will not be put in danger, rather than go to the court, where we will have to deliberate with 15 different opinions, as you can see now, and take a vote when it is not yet necessary to take a vote because it may not be clear that the ambient facts contextualize how we will make a decision. Can that not be a possibility, counsel?
It's a possibility, Your Honor, but then again, I have to admit this may not be a legal question, but whether or not FDA is equipped to do that, considering that we're protecting lives here and we're concerned about lives here of unborn that are totally helpless to do something about their situation, then I think we're pleading before this honorable court to help us do something about it. Technical rules of procedure are there, but then they're not supposed to be there to delay rendition of justice or to deny anyone the fundamental right to life, Your Honor.
We are, of course, very flattered that you will accord us good faith, whereas the FDA may not have good faith in your view.
It's a concern that I'm trying to voice out, Your Honor, because it's not an ordinary matter that we're bringing before this honorable court. We're bringing something of paramount importance, Your Honor, not just to me, to the petitioners, but to each and every one of us, Your Honor. I would say even each and every one of the members of this court, because we're talking about right to life, and right to life is a concern of each one of us. It transcends religion and religious differences. As Justice Abada said, he would not have been here if his right to life was not respected. And, we would have missed the, services and, all the contributions of Justice Abad to the Supreme Court and to the country.
A fact which we also acknowledge, the paramount interest to the right to life, among others, and of course, the paramount interest of having Justice Abad together with us today.
I hope that right to life extends to the very first right, to the very first people who are entitled to that, who are the unborn.
Okay. Justice Bersamin.
Thank you, Chief. Before you are dismissed, I think the Chief Justice will soon dismiss you. I just wanted to know if you were about ready to give us some medical data regarding whatever you wanted to prove by those medical data. Were you?
Figures, Your Honor, we have cited and we will be citing more. We will not discouraged by the impression I'm getting that this honorable court is not prepared to accept findings from medical journals. We will not be discouraged by that. We will continue.
I am going to invite you, if not for myself, then for other members of the court as well, to submit to us learned treatises, which we may take judicial notice of, and as exceptions to the hearsay rule.
Yes. We will do that, definitely.
This is not an unprecedented invitation because
I know that.
If no one else will welcome it, I will.
I'm very happy to hear that. Thank you so much, Your Honor. We will definitely do that.
This will not be about facts. This will be about expert information.
Yes, Your Honor.
Counsel, I hope there's no further question from any of my colleagues because the night is moving on and we have miles to go before we sleep, right? So, please note, Counsel, that we encourage you not to make premature conclusions about our positions here. In fact, if anything, all the questions that were propounded are actually enabling you to prepare a better memorandum.
Yes, Your Honor.
Better that you heard our questions directly and they are given the chance to rectify whatever deficiencies there are than for you to find out that we are debating questions already that you never heard propounded.
Yes, Your Honor.
So please note that this is in fact the nature of these deliberations. We do not prejudge. In the same way that I don't think you should jump to any conclusion as of yet.
I have not come to any conclusion, Your Honor.
Just one note, I was the counsel for the province of North Cotabato in 2008, and the petitioners won. Even though you have been using that to show that this case is not premature, let me point out that there were two factual items that made it very, very different from what we have. There was no other recourse but to go to this court because the draft treaty had already been initialed. Second, people had already died because of violent clashes. That sets it apart and cannot serve as a precedent for you to dispense with the legal requirements for bringing your petition. You still have the burden of proving the same, as suggested by some of us. So
Yes,
please
Your Honor.
note that very carefully.
I will. Yes,
Okay. We will resume our session on July 23, and we will proceed right away with the presentation of Attorney Liban. Yes, on July 23, same venue, same time. If there is no further question or comment from any of my colleagues, the session is hereby adjourned.
All right. Please remain in your respective seats until the Chief Justice and the Associate Justices leave the session hall.